All right, I wanna get started here today and welcome everyone who came in person and the many more people who are joining us virtually today for this panel. And what we're really doing here today, aside from talking about some substance, is announcing the inauguration of the Pennsylvania and Ohio chapter of the Chartered Institute of Arbitrators, held here at the University of Pittsburgh School of Law and sponsored by the Center for International Legal Education, among others. So I'm Professor Charles Katubi. I am the Executive Director of the Center for International Legal Education here at Pitt Law and a co-chair of the local chapter of the Chartered Institute of Arbitrators. And so I want to welcome the students we have here, the students we have are joining us online, many of the members and fellows of the Chartered Institute who are joining us today. And thank you for coming. So very briefly, what is the Chartered Institute of Arbitrators and why is this local chapter important? The Chartered Institute of Arbitrators, for those who don't know, is the leading accreditation institute in the field of arbitration and alternative dispute resolution. Its membership is spread across 149 countries and supported by a network of 42 different branches. Now, Pennsylvania and Ohio, as people know, is home to thousands of global companies who are engaged in arbitration on a near daily basis and an equal number of counsel and arbitrators who serve this market. So having a local chapter here of the Chartered Institute is a critical window to the world for the local business community and bar. Now, the Chartered Institute's mission is to provide education and training along with accreditation for arbitrators, mediators, adjudicators, and counsel, and is to act as a global hub to talk about important issues that arise in ADR. So keeping with this mission and providing a forum for evangelizing arbitration and discussing the critical issues that face the institution, today we're going to talk about an issue that has vexed judges and arbitrators for quite some time, and that is third-party discovery. As lawyers, we know that a regime for dispute resolution is only as good as its ability to find and seek the truth. And if anyone's ever seen the movie Something's Gotta Give with Jack Nicholson, there's a great quote from that movie. They also know that parties to the proceedings often tell the judge some version of the truth. Right? Well, the truth doesn't have versions, as we as lawyers know. And third-party discovery is there to help a tribunal find the truth. But that being said, it's tiresome, it's burdensome, it's expensive. So there's a critical balance that must be struck. So we have two panels here today to discuss some of the mechanisms that parties and tribunals have at their disposal to order third-party discovery and some of the discord, even up to the U.S. Supreme Court, that has arisen. But first, I want to welcome our keynote speaker. So I'm happy to introduce Eric Tuckman this afternoon. Eric is the General Counsel and Corporate Secretary of the American Arbitration Association, which is one of the cornerstone institutions for arbitration in the United States. As the association's chief legal officer, he is responsible for managing the legal affairs of the organization and leading policy initiatives related to arbitration and mediation. So Eric, I'm really happy to have you here today. And come on up.
Thank you very much. And good afternoon to everybody. And thank you for inviting me to this afternoon's program. So the sort of the substantive issues that are going to be taken up today, we've already heard about that. They're going to be described. I'm interested in hearing what the panel's thoughts are on issues related to discovery, third parties. I can tell you from an administrative, from an institutional view, that's a question we get very frequently. What can I do to get information from the other side? Am I going to be able to get the evidence I need to prove my claims in international arbitration? They're horrified at statements like that, of course, because the type of discovery we have in the United States simply isn't available or anticipated in most other parts of the world. Again, I'm looking forward to that conversation and also the issue of that's before the Supreme Court regarding 1782 proceedings and whether you can get discovery in aid of international arbitration. But I also want to note that I'm excited to be here today because many years ago, I lived in Pittsburgh for a short amount of time. I was right out of college, and I lived right up the road in Shadyside. I had a great time in Pittsburgh. I loved it. And I haven't had too much time to look around, but the university, it looks great. It looks like a place that is thriving. I ended up chasing after a woman who had moved to New York that ended well. I ended up marrying her. But yeah, again, before that time, I lived here, and again, it's a great city, and it looks like it's really thriving. So I'll be talking about just a few issues that I think are evolving or pressing with respect to either domestic and or international arbitration. What I think are the issues that institutionally we're facing, issues that parties have indicated are important to them, and the like. So the first issue I'll talk about is really, well, I'll present it as a statement. We need international commercial arbitration now, at this point in time, more than we have in many, many years. So we have significant geopolitical conflict. There is domestic political conflict. We hear a lot about how divisive we are as a country and how divisive the world is becoming. And that's not really an issue I think obviously we can resolve today. But the promise of arbitration, of course, is to provide a neutral place where parties can agree to resolve their disputes, even in light of an environment such as that. So we need arbitration, both international and domestic, to remain a viable and reliable method of resolving disputes. We need it to be credible. We need it to be effective. We need parties to have a belief that if they agree to this process, it will present them with a forum that they anticipate. It's the one they designed, and it will, in fact, provide them a forum that is free from the biases or pressures that they might otherwise feel if they had to resort to the courts of a particular country. So just to be more specific, when you think about this, the United States' top trading partners are Canada, Mexico, and China. Canada and Mexico always been good, friendly partners, neighbors and partners. But what became of the political relationships between the United States and those countries? If you look over the past 5 years, under the Trump administration, NAFTA, the North American Free Trade Agreement, which had eliminated tariffs, was completely dismantled and replaced with another treaty, but was viewed as much more protectionist. Certainly with respect to Mexico in particular, it's fair to say that a lot of the Trump administration's statements and Trump himself were hostile, to say the least. That was part of the campaign. That we were being taken advantage of, and that the United States had to defend itself and change course. As for China, again, that's number 3 on the list of US trading partners. President Trump at the time said that he was one of the few prominent Americans to recognize the true nature of the Chinese Communist Party and its threat to America's economic and political way of life. He said the United States is taking action to protect our nation and its partners from an increasingly assertive China. We're no longer turning a blind eye to the People's Republic of China's conduct, nor are we hiding our criticism of its Communist Party behind closed doors. So clear, direct statements and attacks on that political regime. So at the same time, though, of course, we have, it's not really increased interconnected economic relationships. We are at a point where we really do have a global economy. We rely on organizations, businesses from other parts of the world to be part of our own manufacturing, our own products, the services we provide. It's not just a matter of getting widgets from China to put into other components that are built in the United States. It's also about services. Tech services being provided in India to law firms in the United States. It's commonplace now. It's not unusual. We are totally interconnected economically. So you've got, at the one hand, the strife, discord, political conflict. And at the same time, underneath that, you've got this incredible sort of bond or working relationship between many companies. So if you're a Chinese corporation and you've entered into a contract to manufacture components for a US company, and even though you might have a fantastic business relationship with your counterparty who's here in the United States, how do you feel about the possibility, if some conflict arises, about being sued in the United States in a state or federal court? That's probably the state or federal court of your counterparty's choosing. You don't get necessarily decide. So how do you feel about that? You're probably a little concerned. You're not crazy about that idea. You're not crazy about it, one, because, as we've said, and we'll learn about more, you're not enthusiastic about US style litigation. You're concerned and worried about discovery. But given the current overtones, the political situation, you're also a little concerned about the decision maker, perhaps. The judges you hear, they're appointed by governors, they're appointed by a governmental entity, whether it's state or federal. And if that governmental entity has a stated view opposing your country's own political party, are you concerned about perceptions of fairness? Of course you are. So any judge will say, any US judge will say that their obligation is to decide each case in accordance with the facts, the rule of law, and by reference to neutral principles. And there's no question that's true. But despite the high marks given the US judicial system, particularly as compared to others around the world, the perception of individual parties is likely different. They're still concerned about having to litigate in the United States courts if you are from another part of the world because of what they hear about the perceptions of individuals and political parties from other parts of the world. And again, this is in addition to they're already worried about just the litigation process in the United States. That was a reason for them to agree to arbitration even before you had the conflict that's arisen recently. The same is also true, of course, about the other scenario. What if you're the US party, you've got a contract, and you're getting sued in Chinese courts? You talk to US punk companies, they're not crazy about that idea. They're concerned. They've got the same sense. Chinese courts, judges, are appointed by that same entity, the same party that's being criticized. And the US company says, am I going to get a fair shake? Am I going to be treated fairly in that forum? And I'll say, I've been to China a couple of times, and you talk to in-house counsel of multinational corporations based in the United States, and they've said, the courts aren't bad here. I've had some good outcomes. I'm okay with it. Arbitration has its advantages, but in terms of the process, in terms of the judging, in terms of the quality of decision-making, there are certain parts of the country where I'm not that concerned. They know they need economic development. They know they need to treat parties fairly. So again, I want to emphasize a lot of what I'm talking about are perceptions, but they're important, and they're perceptions that can harm the economic relationships that currently exist and are currently taking place. So look at the more even recent and direct illustration. that we're seeing in the aftermath of the war between Russia and Ukraine. So how many fractured relationships, economic relationships, have resulted from that war? How many companies are we hearing about with virtually no notice are pulling out of Russia? They're leaving their offices, they're leaving their staff, they're leaving their suppliers, et cetera, and they're pulling out. They're simply pulling out. And a lot of those relationships are governed by agreements. There must be just massive disruption among vendors, licensees, distributors, partners, joint ventures, employees, independent contractors. You just go down the list. What does it take to provide a service or to sell or buy goods in a particular country? And all of it immediately fractured and dismantled. And we're hearing about the US companies that are pulling out of Russia. Russia is actually, if you look at trading partners, way down on the list in terms of their sort of ranking with the US as a trading partner. We trade with them, but not in significant numbers. The EU, however, is an entirely different story. It's number 5 on the list. So magnify what we're seeing with the US companies by a magnitude of many, many times. And you'll see the number, the impact of those relationships being harmed as a result of the war with Russia. Again, companies are being pulled out. Companies are pulling out themselves out of Russia from the EU, or frankly, even if they're not, the sanctions that are being posed are prohibiting the companies from having any type of ongoing economic relationship with their current and or former business partners in Russia. So again, just given what's happening right now in the world, and in relatively short order, you're seeing some really significant and dramatic changes in these economic relationships that exist as a result of political conflict. It's having a direct result on economic conflict. Interestingly, and I'll talk about the pandemic as well, we're not seeing this flood of cases come in currently that are directly as a result of either the conflict, the war between Russia and the Ukraine, or as a result of other sort of concerns that have been raised about perceptions or being treated fairly. But there's a tremendous amount of assessment, concern, and I think in the investor state context, there's a big question about whether what's happening now will result in some claims in future years. So this issue, this trend is one that I think just comes to the top of the list when we talk about what's happening with respect to international arbitration in the world right now, because we're going to have economic strife as a result of this political strife. And we've got to have a forum, international arbitration is what I'm saying provides that, that will provide a buffer that will allow the parties to have confidence when they're entering into a relationship with the counterparty who's in a country that might not be popular, that they'll have a place to go in the event where a dispute arises, where they're going to be treated fairly, where they have confidence that they can enter into this relationship knowing that they will have an outcome that they can trust. They'll be able to choose their decision makers. Of course, that's probably the most important decision of all. If they want decision makers that aren't from either country, that are parties to the contract, that's fine. They can find whatever the equivalent of a Switzerland is for their particular case. They can also, of course, choose their choice of law. And importantly, they can choose their process. They don't have to be threatened or concerned if they don't want about being hailed into a process that has more discovery than they want or that has less than they want. Without that, again, you're really forced with a situation where the parties are going to be required to, if they want to pursue a claim, they're going to have to litigate in a court that is going to be perceived to be unfriendly. So this is just to wave the flag. We all need to defend the process. I think it's really even more important, critically important at this point in time, that we make sure that we defend it. Just also, I said the pandemic is sort of a related issue, and it's not one that's political really in any way, but I would say it's also something that came on very quickly and also resulted in a lot of economic impact. So supply chain issues, unfortunately, didn't just spike and go away as we saw with the virus. These are long-lasting effects, and the ability of organizations to provide the service, provide the goods that they want to, produce cars, produce computers. Parties are not able to live up to their obligations in some of these cases, not because they're not working hard, not because they don't have the staff to do it. Sometimes it is a staffing issue that's related, but sometimes you literally just can't get the supplies you need to build whatever you've agreed to build. The pandemic has also resulted, as I say, in a lot of conflict in terms of business partners. I was speaking to a number of lawyers that I thought presented to a pretty good cross-section of international business, some focusing on energy, some focusing more on IP, others just sort of generalists. And the discussion was, what are you doing with the disputes you've got with your business partners right now? And they all sort of had a similar reaction, which is that nobody wants to sue anybody right now. They're all sort of trying to be in this together. They, even if they might have an economic claim, they don't want to be the bad guy. Everybody's having some of the same challenges, and they sort of, they want to be able to view their contracts with just a little more elasticity to the extent they can and still get by. At the same time, they're sort of, I'm getting the sense, I would say, they're sort of parking these claims. They're not throwing them away. They're putting them off to the side. Because after some amount of time, they're going to have to decide either they pursue them or they're going to have to let them go. And I don't think so far they've really just said, we're going to let them go. I'll talk in a minute about some other impacts that the pandemic has had on arbitration as we've seen institutionally. But in terms of what the parties are saying, they really seem to be holding off. And I think you might see something similar with respect to some of the conflict we're going to see as a result of the war in the Ukraine. I think that there's a lot of assessment, a lot of people determining what they want to do. There's probably a fair number of letters going out, putting their counterparties on notice of a claim to come, but whether things are actually going to move in that direction remains to be seen. So there are some parallels there as well. The second big issue that we see evolving is what I describe as a legislative threat. And this is really more domestically oriented. So we're going to shift gears a little bit and really talk more about the Federal Arbitration Act, what that looks like. But the Federal Arbitration Act really is the legislative foundation to arbitration in the United States. I don't want to overstate its case, but it is an important statute. It might be, one of the reasons we're actually convening here today. We've got a national policy favoring arbitration. It's been in place since 1925. It's a very simple statute. There's not that much to it. The heart of it is in Section 2. And it provides that a written agreement to arbitrate shall be valid and enforceable in the same manner as contracts generally. It's just a simple statement that if you're a court, you're not going to treat an arbitration agreement any differently than any other type of contract. And to the extent that you do, or if you draft a law, if you're a state that does, it's just not going to be enforceable. You can't scrutinize arbitration agreements. So those simple words have had this tremendous impact on the enforceability of arbitration agreements. Of course, it reversed judicial hostility. I think at this point, at the federal level, that's really been complete. At the state level, you certainly see some hostility to arbitration in some states, but by and large, the states have at least, if not necessarily embraced, but they've understood and followed the fact that the FAA does in fact establish this national policy. The second really critical thing that the FAA has done, and it's important when you talk about legislative trends, of course, is it preempts state laws that are contrary to the FAA. And I say it's important because you do see quite a number of statutes. I think most people will be surprised. We monitor state and federal legislation across the United States. There are literally hundreds of statutes, laws that are introduced and proposed every year at the state level, which would invalidate arbitration agreements altogether, that require different font sizes. I mean, the Supreme Court decided that decades ago. You can't do that. Again, you can't treat arbitration agreements differently. You can't just say only arbitration agreements have to have a font size that's different. So that's the second critical piece of the FAA. It preempts state laws that are contrary to the national policy favoring arbitration. So what have we seen in terms of efforts to revise that, and why is this happening? Why do we have hundreds of statutes or pieces of legislation that are being suggested, proposed as statutes at the state level? And why do we have, it's not hundreds, but there are tens, 20, 30, I think I've got a list of 30 bills introduced at the federal level that would impact arbitration. Some of them are positive. Some would implement arbitration regimes or processes for certain types of claims. They're a little obscure, mining, certain trademark claims, but it's where somebody has recognized a specific need and a gap. But others are largely bills that would impact negatively the effectiveness and the applicability of arbitration in some contexts. The most, known example of this is the FAIR Act. It's the that's the acronym, Forced Arbitration Repeal Act. That bill has been introduced every Congress since 2007, and it would very broadly, it would make arbitration agreements involving employees and consumers unenforceable wholeheartedly across the board. It's very broad. It also, at some points it's had language that would include things like franchise agreements, which do have, some are concerned about unfair bargaining strength when you get into franchise agreements, and other language that's broader than just consumer employment. But at least for the purpose of our discussion today, we can think about it in that respect. More recently, and I would say much more significantly, legislation did pass that amended the Federal Arbitration Act. The first bill that's done so, again, in decades. That bill was it's long, the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act of 2021. And this bill was one of the first that had bipartisan support. You just don't see much of that right now. But on this issue, when an individual is asserting claims saying, I have been sexually assaulted, I have been sexually harassed, and it relates to a workplace dispute, it's that individual's option, essentially post-dispute, to opt out. It doesn't make the agreements invalid. It makes them invalid essentially at the option of the individual. And some of this comes out of the Me Too movement. Gretchen Carlson really championed this bill. But it had widespread support. And the concern was that the process was being used to hide bad actors, that arbitration was being used to hide bad conduct, repeated bad conduct by particular individuals. And we've seen some awful examples of that in recent years. So it's pretty narrowly tailored. I'm not saying, again, it was the first bill that did amend the FAA in many years, but it did do that. And for these specific disputes, I would say somewhere between, it's smaller than people think, only between 3 and 5% of our employment cases, the AAA's employment cases, actually involve a claim involving sexual assault or sexual harassment. It doesn't rise as much as people would think. So this isn't taking a large swath of the employment caseload away from the arbitration process, at least to the extent that our caseload is reflective of what's going on in the rest of the country. But that is a big change. Just going back though, when this passed, we were going to closely watch what happened to the FAIR Act. Again, that's one with much broader implications and we think is harmful in a lot of respects. But that same bipartisan support that existed for the ending forced arbitration of Sexual Assault and Harassment Act, that same bipartisan support, the universal sense that we've got to fix something that's wrong here, simply went away. And you went back to strict party line voting, the Republicans opposing this legislation, and the Democrats supporting it. The likelihood of this legislation passing in the future is very much going to be tied in with the composition of the House and Senate. Democrats have been fighting for a bill like this to pass for years and years and years. Republicans have opposed it for years and years and years. It doesn't look like it's passing this year. And it all depends what happens with the House and Senate elections coming up at the next election cycle. But it looks like it has an uphill battle, but you can guarantee it's going to be introduced. You're going to continue to have hearings. People are going to continue to debate about the appropriateness and effectiveness of arbitration to resolve consumer and employment disputes. There is a fair and legitimate debate about whether arbitration is appropriate in those circumstances. It's the association's view that arbitration can be incredibly effective. Not every case is well suited for litigation. It is time consuming, it's expensive, it is draining. Arbitration is flexible. You've got to have arbitrators who are, for those types of disputes, experts in that field. You're not going to have a construction, excuse me, Albie. I don't know if you got an employment background, but unlikely you're going to be pointed to an employment case, right, involving statutory claims. We have protocols, and that's our solution. Instead of simply dismantling a process that has really become relied upon by many, both individuals and organizations, it's much better to improve it by implementing standards that are going to ensure that it will be fair. Expert decision makers. You can't shift fees to employees. You've got to give employees some ability to access information to prove their claim. In other words, this is a word for it, some limited form, at least, of discovery. Our protocol, we will actually reject a case. We will decline to administer it if the arbitration clause limits the damages that are available. You've got to have the same remedies available in arbitration that you would otherwise have in court. So again, if you have some fairness standards that are again, somewhat universally accepted at this point, we feel that's a much more appropriate and better solution than simply eliminating arbitration altogether. It has become a partisan issue. I will add that. It's not one where, unfortunately, the facts have been very persuasive to either side. I've heard some incredible statistics about the loss rates for employees when you talk about the people that are encouraging passage of this bill. They're talking about our caseloads. They're completely incorrect. So we need to watch that closely. In the short term, that legislation, broad legislation impacting consumer employment, unlikely to pass. At the state level, I talked about preemption of the FAA. Despite that, you're seeing a lot of legislation that would still make arbitration agreements involving employees unenforceable. Confidentiality is a huge issue of importance to state legislatures. They're concerned about not being able to learn about bad conduct. And so they're passing laws stating that the outcomes or the arbitration process involving arbitrations where consumer employment matters are being handled need to be somehow publicly made available, either through reporting, by releasing individuals from their obligation of confidentiality. Again, our rules don't impose confidentiality on the parties. They do impose confidentiality on us as an institution and on arbitrators, but not on the parties themselves. To the extent that exists, it's because it's part of the party's underlying contract. But there's a huge amount of concern about the confidentiality of the process. States are very active in that regard as well. Our concern with all this legislation, much of it overreaches. If it were to pass, although not intended to, it would impact some of the commercial arbitration agreements that are currently in effect. And we think that is quite harmful, and that's a big concern. So to the extent we can, we try to be active and have a voice on this. But that is sort of issue number 2 in terms of what we're seeing with regard to major issues. Also on legislation, I should note, I think that in some respects, all these tensions, many of these tensions arise because of arbitration, the successes of arbitration. It's being used in ways, employment, consumer, $100 million cases, $1 billion cases that you didn't see as much 20 or 30 years ago. And so with these increased stakes and sort of one statute that applies to all these different types of disputes, you're seeing a lot of pressure being put on state and federal arbitration statutes. Again, we hope that they will be maintained and that we can address some of these concerns through other means. But I think that's where we are today, and it's going to continue. That trend's going to continue for many years to come in terms of proposed legislation. Issue number 3, technology, right? So what hasn't been impacted by technology? The sort of predictions for massive change in the legal field. This is not just arbitration. I was at a legal tech conference. I think it was probably the first conference I've been to since the pandemic. And it was interesting because it wasn't about arbitration particularly. And it wasn't, I would say it was more of a tech conference than a law conference. But there was, again, a universal sentiment that lawyers are pretty slow to adopt technology. And think about, for those who have actually been involved in arbitrations, there's been changes over the past, let's take us, before 3 years ago, some changes certainly in the way arbitrations proceeded, but, they were still about getting together in person, sharing evidence, issuing written awards, that comply with whatever law might apply for issuance and enforcement of awards. But, no real rapid development that sort of went across the field. Arbitrations pretty much took place in the way 3 years ago that they did 10 or 20 years before that. I think in the next, starting with the pandemic, in the next 10 years, you're going to see the rate of change is going to increase dramatically. The pandemic pushed us in that direction. All the technology that we needed to handle arbitrations during the pandemic, it all existed before. It wasn't an invention of necessity. We've been offering virtual hearings for years and years and years at the AAA and ICDR. But there was there's a lot of inertia. The pandemic did sort of kick everybody pretty rapidly in the right direction. And I'm glad to say, organizationally, we were able to accommodate that very easily because it's something we had been sort of trying to work and push on before. But we're not going to go back, I don't think, to in-person hearings for every single hearing you have to have. Arbitrators are pretty adept at Zoom now. Zoom is going to continue to refine its process. They're going to be able, I'm not saying something that I actually know, right? But they're going to change the breakout room process so people feel more comfortable about that. I really am sort of making this up, but I know what the limitations are. They'll refine their service. It might cost more, I don't know, but there's going to be this continued effort for that technology to accommodate what everybody wants. That technology isn't necessarily developed for lawyers specifically. It's a virtual meeting program for everybody. Maybe there's a new version of it that is perfectly suited and developed for arbitrations or for litigation. But we're going to see some pretty continued and rapid change. Just the way you hear parties talk about remote hearings, how evidence is exchanged, how they're going to present it. It's all very different than it was 3 years ago. For large cases where there's a lot at stake, they're sort of bet the company matters. The parties still want in-person hearings. They're waiting for the day. We keep on getting blocks of our hearing rooms that are sort of filled up. I'd say, starting in April, things are starting to get very busy. But we've been through this routine before too. We've had last August, all our hearing rooms were booked across the country and they all canceled. They all went virtual because there's a spike that happens or a threatened spike and because people are comfortable doing things remotely. It's not as smooth as I'm saying. You don't just go online. Some parties don't agree. Some arbitrators don't agree. Some arbitrators are saying right now, I will not do anything in person. I'll put it on my resume if I have to. I'm a virtual only arbitrator. And some of the opposite. I'm an only in-person arbitrator. I will not do remote hearings. I don't know how to use it, or I don't want to learn how to use it, or I don't think it's good for my decision-making capacity. I want to see people. But that's all fleshing its way through. I will be brief with my sort of last thought here. And this goes back to international arbitration. I wish it was the same with domestic arbitration. But the desire and interest in international arbitration seems to be endless. And think again about our meeting here today. The Chartered Institute is establishing a branch here. There is a geographic push everywhere in the world to establish places where lawyers or interested people can go to be involved in the international arbitration process. The number of institutions, arbitral institutions worldwide that have developed in the past 10 years is incredible. Every country wants to be known as having an institution that's viable and credible. We've been involved with some of them. Frankly, there's not enough arbitration going on, even with this increased demand, even with increased case filings, to keep all of these institutions sort of viable on their own. But even if they're not administering cases, they're serving as a local, they serve as a local source of thought leadership and also legal leadership to say, this is a place, this is a country, this is a city where arbitration, international arbitration is important. And we have lawyers who are knowledgeable and expert and that can handle cases here. We have facilities that are good for arbitration. It's all good for international arbitration. At the same time, it is, I say, it's almost this insatiable thirst that we are seeing. Again, it's a good trend. It keeps people energized and enthusiastic in the process, and we hope that will continue as well. So I will conclude my comments here, and I'm not sure if we have time for questions or not. Okay, thank you very much.
Thank you. So I think we just move into the first panel, so as not to lose any of our friends who are online here. And brief introductions to yeah, we can take 5 minutes. Yeah, let's take 5 minute break, and then we'll move into that panel. Welcome back, everybody, and everyone joining us online. I hope you stick with us. So I think one thing that Eric talked about that is really critically important is that no matter how broad our viewpoint of international arbitration, how global it may be, we really do as the architects of this system have to be mindful of what is happening at the state, local level regard to arbitration to make sure it doesn't become hostile to the regime, because this is something that we've all created that is important to keep. And on that topic of statutes, what we're going to talk about now is the FAA. Is one provision of the FAA that has given a lot of given rise to a lot of turmoil with respect to arbitration. And I'm really happy to introduce this panel to talk about it today. Now I'll let our moderator introduce everyone, but I'll introduce you, Albie, if that's okay. So our moderator here is Albie Bates. He's a partner in the Pittsburgh office of Troutman Pepper. He acts as party counsel in domestic and international construction disputes primarily, and has served as an arbitrator and a mediator in more than 150 U.S. and global cases. He's a fellow in the Chartered Institute of Arbitrators and has also served as a member of the board of directors of the AAA ICDR. So, Albie, I'll leave it to you and take it away as the moderator.
Well, thank you very much. As Chuck said, we're pleased to be here. We'll say hello to everyone that's joining us virtually, as well as all those in the audience. So thank you for being here. We certainly appreciate it. As Chuck also said, we're going to talk a little bit about Section 7 of the FAA. Really, we've got 4 topics we're going to talk about as we go through this. First, we're going to give everybody an overview of Section 7 of the FAA and what the current status of enforceability of discovery subpoenas is in the various circuits around the United States. And then talk a little bit about the best practices in dealing with discovery subpoenas in those jurisdictions in which they may not otherwise be enforceable, and how we get around that and what the best practices might be. Second, we're going to talk about the same analysis, but what happens when we're dealing with virtual hearings or virtual depositions. How has the last 2.5 years or 2 years taught us about what Section 7 really means and how judges applied that to virtual hearings, where there's no inconvenience to someone showing up in their living room and turning on their computer to appear for a deposition, for example. Third, and I think the issue that will spark a lot of discussion among the panel, and we welcome any questions that anyone in the audience or anyone joining us virtually might have, is what's the role of the tribunal in determining whether subpoenas should be issued initially? Some people take a very laissez-faire attitude toward that issue. And if the parties agree to the subpoenas that are being presented and there's no objections raised, they get signed. Other people take a very inquisitorial view. They spend a lot of time digesting what's in the subpoena and making an assessment as to whether or not, first, is the subpoena is enforceable, and second, whether it's something that should, in fact, be issued. So wide difference of opinion among domestic arbitrators on that issue. And then finally, to tie this section to the next one that we'll hear about with 1782, what are the implications of Section 7 of the FAA on international disputes? So with me, we have 3 very esteemed panelists. And I will start from the far right and work my way down. So to the right is Zach Torres Fowler. Zach's a partner at Troutman Pepper in its construction practice and co-heads the firm's international construction projects practice. He concentrates his practice on construction-related disputes, specializing in complex domestic and international arbitration proceedings. He has experience before arbitral panels and tribunals under a wide variety of U.S. domestic and international arbitration rules, including the AAA, JAMS, ICDR, ICC, LCIA, and ICSID. Zach has advised clients in connection with construction infrastructure projects in the U.S., in Africa, in the Middle East, and in Latin America. Zach is a regular author and speaker in the field of construction international arbitration and serves as an adjunct professor at the Charles Wagner School of Law at Villanova University, where he teaches courses on international commercial arbitration. So Zach, thank you very much for joining us. To his left is Tom Chris. Tom is a construction lawyer, an international arbitration and commercial dispute specialist headquartered in the United States and the UAE, is Midwest Regional Manager of the Society of Construction Law, and is a fellow of the Chartered Institute of Arbitrators. He is founder and chairman of Benish's Global Infrastructure Team, the Middle East practice, and is co-chair of Benish's Construction Practice Group. Tom is admitted to practice in all courts in Ohio, Texas, New York, North Carolina, District of Columbia, and the U.S. Court of International Trade. Is a registered legal consultant in the UAE and appears before and sits on various arbitral rosters, including the AAA, the ICI, the LCIA, the Dubai International Arbitration Committee, and the Saudi Center for Commercial Arbitration. Tom, thank you for joining us today. Last but not least is Catherine Smith-Diedrich. She's an experienced commercial litigator, arbitrator, and co-founder of a domestic and international disaster and insurance consulting company based in the U.S. and Asia Pacific. She's handled hundreds of complex commercial matters throughout the U.S. and other countries, including New Zealand, Australia, and Chile. She has significant experience both as a party representative and as a neutral, including complex reinsurance, environmental contamination, and various other complex commercial disputes. Catherine is a neutral with AAA and FINRA, a fellow and chair of the North American branch of the Chartered Institute of Arbitrators. She's also an author of the award-winning legal thriller series, Deviant Agendas and Private Agendas. She's currently working on her third book, which I'm just guessing might have agendas in the title. I don't know that. She's saying that to scoop for us as we go along. Catherine, thank you for joining us as well. So for our first topic, which is the overview of Section 7 of the FAA and its enforceability, I'm going to turn the floor to Zach.
Great. Thank you, Albie. I'm often soft-spoken, so I think I'll use the microphone a little bit, but if that's too loud, let me know. So first, thanks to Chuck for inviting me. Thanks to the university for having me here. It's really quite an honor. I think I want to frame at least part of our discussion about why is third-party discovery valuable? I think to American practitioners, the answer is pretty obvious. Get documents you wouldn't have otherwise access to, get access to people you wouldn't have otherwise have access to. And oftentimes, I think in practice, you'll find that some of the most credible witnesses you see in a case are the ones who don't have access or who don't have an axe to grind. So they often become the most credible. But I think to non-US practitioners, the answer to that question isn't so obvious. And I think it really depends on your perspective. And so I want to flag that, and we'll come back to it later on, but I think part of this discussion really focuses on what are the objectives of arbitration? Is it really sort of truth-seeking, which is really one of the preeminent goals of our legal system in the United States, or is it efficiency? Or how do you balance those? I think that's something that Chuck was talking to earlier. Now, I by no means will be able to give Section 7 of the FAA justice. I will try to highlight some of the issues that have come up and confounded the courts in the United States, but I find this subject to be very much like peeling back an onion. You can talk about some of the circuit splits and different opinions from various courts, but the more and more you look into this issue, the more and more you uncover that there is so much confusion, and it is a very fraught issue. So I think as most US practitioners will appreciate, third-party discovery is the norm. You can seek subpoenas to access documents, depose witnesses from non-parties relatively easily in the United States through Federal Civil Procedure 45. And it's very true for state court civil procedure practice as well. And the US has made that very streamlined. The federal rules were amended about a decade ago, and the process for third-party discovery is a fairly straightforward process. Now, that isn't necessarily the case for arbitration practice in the United States. And this would be arbitrations seated in the United States are really governed by the FAA. And part of the reason why there is this distinction between third-party discovery and the US courts and third-party discovery in arbitration is due to the language of Section 7 of the FAA. And I can't recite it for you. It's a giant block of black text on my notes, but it was written in 1925, and it has confounded courts ever since, especially as discovery practice in the United States have evolved over time. And so I'll kind of preface a lot of this on is that I know the hot topic of the day is 1782, and you'll hear a lot about that in the next panel. But I think the US court's treatment of Section 7 of the FAA is equally important, if not more important, for clarifying this practice. Because I can almost guarantee you there are more third-party subpoenas issued and requested in arbitrations in the United States than there are 1782 applications. And that this is something that really practitioners, arbitrators really do need to appreciate, because treating arbitration just like federal court litigation would be an error. So I want to flag two issues that have come up across the courts over two basic issues that you see troubling courts and where there are circuit splits about the application of Section 7. The first is the arbitrator's authority to issue a request or order pre-hearing third-party discovery. And the second is the territorial limitations on enforcing third-party subpoenas through arbitration. The first issue, pre-hearing third-party discovery, really pertains to the question of, can arbitrators order a non-party to disclose documents or give testimony prior to an in-person hearing on the merits? That in essence is the question. And that may seem like a silly question, because in federal court litigation, that happens all the time, right? But the problem is that the text of the FAA of Section 7 really does imply that in order to have pre-hearing third-party discovery, you have to have an in-person hearing on the merits. The third party or the non-party has to appear before the arbitrators, give their documents, or submit their testimony. That is in essence what the FAA on its face seems to suggest. And so there are a variety of circuits, the second, the third, the ninth, that have all held that the FAA does not authorize arbitrators to order a non-party to submit documents or give testimony before a hearing on the merits. Conversely, the Eighth and the Sixth Circuits have held, no, that's not actually true. It's implied within the bounds of Section 7. We will authorize arbitrators, we will enforce subpoenas that order pre-hearing discovery. And then the Fourth Circuit has held, well, we generally follow the second, the third, and the ninth, but we might allow pre-hearing discovery under special circumstances, special needs. What that means really has been yet to be defined. And so we'll talk about some of the practical, how you get around that, because some of the courts have suggested clever ways of getting around that issue. Because it does seem somewhat odd to require third-party discovery to only take place at a merits hearing. It's a practical matter. You want to see the documents and the evidence before you actually have to present it your hearing. So we'll talk about that in a second, but I want to focus on the other issue, and that's really the territorial limitation of enforcing third-party subpoenas in arbitration. Section 7 of the FAA makes clear that the district court where the arbitrators is sitting have the authority to enforce these subpoenas, and that would limit their authority to enforce the subpoenas to their own jurisdiction, within 100 miles or within the district or within the state. What happens though when the arbitrators sitting in that district issue a third-party subpoena to a non-party who sits outside of that jurisdictional reach? Second Circuit, Third Circuit have held, too bad. We won't enforce a subpoena for a non-party in our jurisdiction that sits outside of our jurisdiction. We don't have personal jurisdiction over them. Now, there are ways to get around it again, and there's a lot of nuance, but that is what the Second and Third Circuit held. One good example is the Second Circuit refused to enforce a subpoena for documents issued by a tribunal or panel seated in New York against a non-party in Houston, held that they didn't have the authority under Section 7 to enforce that subpoena. Now, as you probably expect, other circuits disagreed. The Eighth Circuit has held, no, that's fine. Section 7 does in fact allow nationwide service of process. It allows all district courts to enforce, anyone in our circuit can enforce these subpoenas, regardless of whether or not the non-party is located in our jurisdiction. And so there is a lot more to this subject. Like I said, it is very much like an onion. And the more you look at it, the more complicated it gets. But I'll kind of stop there because I don't want to lecture too long. But I want to give everyone the impression, the understanding that this is a fraught area of the law. And if you don't approach it with care, at least from a practitioner standpoint, you risk really upending or disrupting the arbitration process in some ways and improving the efficiency that you're really seeking. So with that, I'll turn it back to.
Before we talk about some of the workarounds, I'll call them best practices. It would be useful to hear from Tom in terms of how the virtual world has changed that. What have the courts done recently when somebody's not physically appearing in front of the tribunal, they're showing up on a computer screen via Zoom?
Sure. I'm Tom Christ. Are there any law students here? Saw a couple. Okay. Someday someone's going to pay you to know this, which is something you should really think about. I started my career jury trial after jury trial after jury trial. And then because my practice migrated to construction law, which is predominantly most disputes are heard in arbitration, moved that way. And then I have moved to an overseas practice as well. So I see it from multiple different angles. And I think that the fact that you're here means you are way ahead of everyone else. And I say that because for the arbitrators in the room, how many times do you have appear before you an experienced commercial lawyer, commercial litigator who is not experienced in arbitration? I see John nodding his head. So what happens is those very experienced commercial trial lawyers come in and make all these fantastic arguments. And then the person sitting across the table who has a lot of experience in arbitration just sits and says, okay, sit still for a minute, and just knocks them out one after another, because those arguments that make perfect sense in a trial court tend to make less sense in arbitration until recently. So, I think Zach has raised a number of really interesting issues about different courts, different circuits making different decisions with respect to how to interpret the FAA. So I think that as law students, as you'll learn once you're in practice, a big part of your job is controlling expectations. So there's this thing called BTI. I looked up, I've known as BTI forever, but it's the Bertelsmann Transformation Index. You can look it up online, BTI Country Index. And what it does, it looks at emerging countries around the world, over 150 of them, and it rates them in different things. And one of the things that's very important to emerging nations is predictability of the legal process. So you can look at some countries and see that, for instance, I practice in the UAE, and Dubai has had very well developed arbitration rules for a long time and ranks 9th on the planet in emerging nations as far as sort of friendly legal process. Other places, not as much. So imagine today you get a call from a client, you're practicing or you're clerking and you're asked to look this up. And the client says, I have an arbitration that's seated in the US. I need to know what the process is going to look like. Will there be third-party discovery because I want to control costs the best I can? And your first question has to be, where's the seat? Where's the seat of the arbitration? Because if it's in some jurisdictions, you can tell them this is going to look a little bit more like traditional international arbitration. If on the other hand, you're in a different jurisdiction, you may say buckle up for depositions. So there's a recent case from the Eighth Circuit. Zach had mentioned it in part, a dispute between Target and a supplier, Target and Seaway. So Seaway supplied some goods to Target, filed an arbitration demand against Target because Target didn't pay. Target counterclaimed saying the goods were defective. The parties, by agreement, asked the arbitrator to issue a subpoena for a non-party witness who was a former Seaway employee. And that witness agreed voluntarily to appear virtually for a Zoom deposition. No issue so far. Then Seaway's counsel instructed the witness not to answer a number of questions and not to share certain documents that he was supposed to bring with him to the deposition. Subsequently, Seaway dismisses its claims. Target continues to prosecute its claims and asks the arbitrator to issue another subpoena for 3 hours to take the virtual deposition of that former employee. Try this one was in New York. This is 8th Circuit in St. Louis, and asked for a second deposition simply to go over the things that should have been asked about and answered at the first deposition, but weren't. And all of the arguments that the parties make are half the arguments that you would expect commercial litigators to make, and the other half are those you would expect those of us who've spent a long time in arbitration to make. So Target's position in support of the second deposition, in-person or virtual deposition with documents, was the 8th Circuit has precedent that supports the arbitrator's authority to issue a subpoena for pre-hearing attendance of a non-party at a deposition with documents. Their second argument was judicial estoppel, which I think is really important here. Target said, well, wait a minute, we all agreed to depose the third party witness once. He refused to answer some questions. Your agreement just can't go away now and prevent me from coming back and finishing the deposition. The witness also argued that because he was in a different state, he was outside of the jurisdictional limits of the court, and the appearance would be unduly burdensome. Those are great commercial arguments that are made in court every day. Now, the arbitrator noted that he believed he did have authority, didn't comment on judicial estoppel, made some early decisions in the arbitration related to convenience, and proceeded, issued the subpoena. So ultimately, the 8th Circuit addressed each of these issues and found that there was no dispute that the 8th Circuit had precedent allowing pre-hearing paper discovery. And then by analogy, there was no difference in that same precedent differentiating between paper discovery and taking a deposition, even though those are radically different things. The court further determined that the 100-mile rule doesn't matter because the deposition was virtual, and said there's no inconvenience on the witness because he's participating from home, sitting across from his computer. Shortly thereafter, same year, the Southern District in New York went the exact opposite way on almost the identical arguments. So an arbitration seated in New York, the witnesses that one of the parties wanted to get, from whom one of the parties wanted to obtain documents and depose, were in Virginia and in California. It had already been determined that the arbitration would be virtual because of COVID. Those two witnesses ignored their subpoenas, and one of the parties sought to enforce it in court. And the court didn't look to inconvenience and the 100-mile rule. Instead said, the FAA requires the witness to come before the arbitrators in their presence, and other language citing appearing before the arbitrators or a majority of them. This court specifically found that the sitting across from your computer far away from the court doesn't count, in essence, as presence before a majority of the arbitrators. So determined that in that case, the subpoenas could not be enforced. Within a few months of that, in a FINRA arbitration in Georgia, one of the parties sought attendance at a deposition with documents of two witnesses who were in Puerto Rico, and the district court in Georgia enforced it. It said they don't have to travel from Puerto Rico to the US. They can sit in front of their computers. There's no inconvenience. The 100-mile rule doesn't matter. And that court interpreted the FAA as saying virtual deposition is good enough. So what I'm seeing in practice, both as an arbitrator and representing litigants, is one, lawyers will ruin arbitration if they're given an opportunity. Okay. Arbitrators will ruin arbitration if they're given the opportunity.
Hey, watch that.
and so will courts. So, the goal here is to not be in a situation in which you have deep litigation going on in court while you have deep arbitration going forward at the same time. Clients don't like that. They're not prepared for that. They're not prepared for the expense. And then to sort of wrap that thought, as the years go by, I have a partner who's tried innumerable cases. And he says, every year that goes by, I need less information to win my cases. Which really means he's better at focusing on what's important. So for the law students, to me, the absolute most important thing about practicing law is being able to figure out what is important and what isn't when you're in trial. Because you can really beat it to death and win on 5 issues. But if there are 9 and the other side wins on the other 4 and cleans your clock, you're dead. So I think here, when I'm the arbitrator, and I know we'll get to this in a little bit, but I don't issue defective subpoenas. So if we're in a jurisdiction in which they're not going to be enforced, I won't sign them. I don't mind parties asking, but I won't do it because I'm not going to contribute to the problem of giving, no offense to judges, but judges an opportunity to make the one-off bad decision in a jurisdiction that has already clearly gone the other way in a case that I'm a part of. So I think that Zach spoke about, are we looking for the truth? We're looking for an efficient version of the truth. As an arbitrator, when I see these battles for third-party witnesses, more often than not, they come in and they say the exact same thing that the parties have said 9 times already. And it's not helpful. Other times, as Zach mentioned, that person who has no dog in the fight, who was a former project representative or employee, a construction manager, who comes in and says, I don't care how this comes out, but this is what happened, this is what I saw, and this is what I remember, can be valuable. So there's temptation there. And when you're the arbitrator, you do have to listen and think about who's asking, what do they claim this person is going to say, and is it really going to have weight? Or is it just you close the evidence and you have 6 people that say the sky is blue and you have 6 people that say it's not, and you're picking?
I'd like to come back to the role of the arbitrator in just a minute, but leaving out the situation you described, where some very creative lawyer figures out a way that there's a litigation going on that allows them access to some discovery, at the same time that there's an arbitration going on that doesn't allow them access to certain discovery. We'll leave that one on the side for now. What do you do in the normal case? You're in New York, you're in the Second Circuit, and whether you're the counsel or you're the arbitrator, there's a very important witness out there that has useful information to you. What do you do? What's the best practice in obtaining that information as part of it?
Well,
I
go
throw that out to Kathy.
Go ahead.
No, go ahead, Kat.
Well, you're the one in New York, so I'm going to let you take that.
So the question is, there is a third-party witness who clearly has some valuable information, and you're the arbitrator. What do you do?
The arbitrator believes the information is valuable, and at least one of the parties believes the information is very valuable. What can you do? What's the best practice currently?
Well, so assuming we're in the Second Circuit, or you have a prohibition against pre-hearing third-party discovery, what some courts have suggested or recommended is to have what essentially I would call a mini hearing, where you convene a hearing where you pick the site if you want to, which can have a really significant legal ramifications actually. But you convene a mini hearing where the non-party appears, provides their documents, provides their testimony in front of the arbitrator, close the hearing and move on. That would be, several circuits have said that is appropriate on the FAA. To me, it strikes me as being extraordinarily inefficient, sort of counter to the whole goals of having arbitration to begin with. It also seems to simply circumvent the entire intent of the FAA, or at least the text of the FAA. And what is the purpose of calling or stating in the FAA that you have to appear before the arbitrators to give testimony, which clearly appears to mean appearing at a merits hearing when you can simply run round around that obligation by convening a quasi hearing or a mini hearing that doesn't actually decide the merits.
Well, you can, I think the alternative, and maybe a little bit different than what you discussed, and I think that something that happens is you convene the hearing. You have the hearing, the witness comes in. Everybody gets one shot, right? It's not a discovery hearing. It's a merits hearing. So the person's coming in, you know, everybody better really believe they've got useful information, or you're spending a lot of money and being very inefficient in the way the process moves forward. But I think under even the Second Circuit, you have the authority as the arbitrators to do that, if that's something that you believe is really important for the particular case. When you exercise that discretion, it's our next topic we're going to talk about, but you certainly would have that authority. I can tell you anecdotally, this may be useful for some of the people in the audience, that I've been on panels where we have done that on 5 occasions that I can recall. How many times have we actually had to have a hearing? 0. Because once the arbitrator said this is important enough that we're going to get on a plane and we're going to go to the location, all of a sudden that little dispute got resolved. And usually there's less information provided than one side wants, but more than the other side wants. And it's presented to you in a much more efficient way when you get to the hearing. So that's typically what has ended up happening in my experience.
Now, that's a great answer, but how do you predict if 5 years from now, you guys are all in practice and you have to tell a client that might happen? I mean, that might be how if you get a really smart arbitrator, here's what he might do. Or he might say, where's the witness? Well, the witness is in St. Louis. Well, that's in the 8th Circuit. So I'm going to convene the hearing for a day in St. Louis. Where that court would enforce the subpoena, we're going to take it there. I think that's a right answer, but very difficult to counsel your client. And I will tell you, it takes time and practice until you fully realize how expensive all of this is.
Right.
And when you say to a client, if there's third party discovery of the scope that the opposing party wants, you're going to spend another $500,000.
Right. I think that's one of the most important overriding issues of concern is arbitration is obviously supposed to be truth-seeking, but it's supposed to be efficient, quicker, and less expensive. That's some of the advantage for, as you advise clients, you'll see they want done. They often think of litigation as long drawn, incredibly expensive, and not worth it. So one of the things I talk to my clients about in the arbitration agreement is what are the types of disputes when they have me drawing their business contracts that you experience most often? What are they and where do you expect them to be? And in that regard, then you can talk about how fast do you want those resolved? How do you want to handle that? Would you rather go to the courts and advice on the law and where it might be, or would you rather pick a place of arbitration, limit the arbitrators, limit the procedure? We talked about that a little bit. I'm a believer in that. If you don't want a long drawn out, you can put that information into the arbitration agreement, because in these situations, you can certainly imagine where, based on Section 7, and I don't know how many of the students have read Section 7, but I'm sure all of them. Yeah, I'm sure you've got it right in front of you. But I think it's important to note there's really, in my mind, for this discussion, 2 parts. It says that the arbitrator can summon any person or documents that are deemed material as evidence. That's the first part. But then what if they say, well, we're not coming. We don't care what you're doing. Then the second part is that upon petition to the U.S. District Court for the district in which the arbitrators or a majority of them are sitting may compel, right? So you've got 2 parts. The arbitrator can issue the summons and get it out the door. But if they say we're not coming, how do you enforce that? Which is what we've been talking about. But I'm going back to the writing a little bit because Zach mentioned it's the seat of the arbitration. In my opinion, this statute doesn't say the seat. It says where you're sitting. We're all here right now, right? So maybe if you convene in another state where that subpoena issued, maybe it's California, you're sitting there, and now that district court can enforce that, right? So it's very interesting when you're drafting these agreements, you might want to put this, you should have it set out at where the seat is, what the law is, et cetera, and talk about maybe at the pre-hearing these issues that if they come up, what are you willing to do as a panel and as the parties?
Right. One of the reasons I smile about that is we had this discussion earlier where I teach a class at my firm every year to our corporate lawyers. And, 20 years ago, one of them gave me what he thought was the best arbitration provision ever. And I read it and I walked into his office and I said, why don't you just make jokers wild? Or say one arbitrator has to be left-handed. I mean, it was so specific with pitfalls You know, the one we see all
I
the
like
time is,
left-handed.
well, see, we have one where we see all the time. A party will pick an arbitrator, the other one will pick an arbitrator, and they'll pick a third. But what if they don't? What if they can't? Well, then you wind up going to a judge and asking the judge, who's never going to hear your case, to select your third arbitrator. Or, you know, these incredibly specific deadlines for everything that has to be accomplished. What if it isn't? What if it isn't? Are you waiving other provisions? However, after doing this for, 27 years, I'm now, with some of the changes that are recent, saying that, and I asked Albie earlier, if parties in an arbitration pull out an arbitration or pull out a contract with a provision that says there will be no third-party discovery, and one of the parties says, yeah, but I didn't write that, and I didn't represent the party when they signed it. I need third-party discovery. Do you care?
The answer is not if it's in that arbitration.
If it's in the agreement.
And the parties haven't agreed to the contrary, right?
Right. Which part of controlling expectations may be to counsel clients that because I don't know what the different circuit courts in the US are going to do on this issue, we may have to add some of these discrete things to your arbitration agreement, such as no third-party discovery. Now, invariably, if you draft that for your client and they sign it, when the arbitration is filed, your client's going to say, we got to get around that. Because in this one, I decided I really need a whole bunch of third-party discovery. And my fallback is always that just ask them questions at the hearing. So a lot of lawyers are scared to death to go into an arbitration and ask questions of a witness who they haven't deposed and whose paper they haven't seen before that.
But I will say in other countries, New Zealand, Australia, that's often done. It's not unusual to not have that. In the US, it's just, go get what you can in litigation. And so it's not something that is shared thought around the world.
Sure.
But here the lawyers are trained, of course, right? Did you go get that? You never want to say, I didn't ask for that, right? In litigation, that's how you're trained. You might as well kind of get everything and then narrow it down. So
if you're searching for the truth, what's more likely to get you to the truth? Someone you've never met, who the other side has never met, showing up with a fistful of paper and sitting in a room for the first time in an arbitration and answering questions, or someone who is deposed, who's produced all of their records, and then comes back a second time for an actual hearing and testifies. People don't like being made to look bad when you're asking them questions. It's not unusual for people to change their stories between a deposition and after they study a little bit and they come into a hearing. I'm very comfortable having the person show up, flip through their paper, and let's get it on.
We'll transition us over to our next topic, but before that, I want to kind of echo something that Eric said a few minutes ago and add one additional thought on this topic before we leave it. First is, to me, there really are two things that are incredibly important about arbitration. We can talk about efficiency, cost, all those things. Leave that to the side for now. I'm talking about non-economic pieces of it. One is the flexibility that the process provides, right? So you, as the lawyer meeting with the other lawyer, can craft this process with a good arbitrator to be what it needs to be and achieve the efficiency and achieve all of these things. So I get a little concerned when the clauses that are written into contracts hamstring the ability of good counsel, when they get the dispute in front of them, to put together what needs to be done for this case, or that limits what an arbitrator can do. The second point, in addition to flexibility, you pick your judge. You determine who the arbitrator is going to be. And if you pick the right arbitrators and give that a sufficient amount of thought, you can eliminate many of these kind of crazy one-off sort of scenarios by having good, competent arbitrators that are going to manage the case properly and deal with these kinds of issues. So with that, I transition to Catherine, and you're given a bunch of subpoenas, or you're one of the lawyers requesting a bunch of subpoenas. What's the role of the tribunal when those subpoenas come in? Do they just sign them? If there's an agreement of the parties to do so, do you conduct a review? What do you suggest is the appropriate way to handle that issue?
I think that you have to do more than just sign them and send them out. If you're an arbitrator, I think you're supposed to be in control of the matter and make sure that it's operating efficiently and effectively. So I would not just sign and send, even if there's an agreement of the parties. Obviously, they have to, evidence they're asking for has to be material. That's in section 7. So I think you should take a look, understand what they're asking for and why. I think some of the other things are is it a fishing expedition? You know, that's, again, it's not litigation, it's arbitration. What are they trying to get and what is the purpose? But I also think it's important, especially if we're talking about non-parties for these subpoenas, where are they located? Where are these subpoenas going? And how are they going to be enforced, right? So if we're going to go to the Ninth Circuit, there's a Jones Day case out at the end of 2021 that talks about the formal seat of the arbitration was Washington, D.C. The subpoena went to entities and people in California. And Jones Day said, hey, Federal Rule of Civil Procedure now allows nationwide service of summons, subpoenas. So there's no reason why you can't enforce it. And the court said, absolutely not, because the seat is in Washington. We do not have the authority to enforce it. Now, they did note that the parties to that arbitration had not indicated that they were going to hold a hearing in California, as we've been talking about, for the purpose of accepting this. So they declined to enforce it. So I think you have to figure out, where are they going? What if one's going to California, Ninth Circuit? What if the other's going to the Eighth Circuit, which will apparently let everything fly? And so what do you do with that? Then do you have, the Ninth Circuit subpoena can't get enforced? Or do you, I think you have to be very careful on that and say, okay, do the parties agree? Are we going to convene if someone refuses and it's not the Eighth Circuit? Are we going to convene over here to get this done? So I think it has to be orchestrated, just like you do at the beginning of the arbitration to talk about all of these issues.
Other thoughts?
Well, one question, and I don't know if I have the answer to this, but what's the problem? Like, the parties want, if they agree they want third-party discovery, arbitrators say, fine, we'll sign it. You guys do what you want to do, fight your fight, see what you want to see. I don't care. As long as we get to the hearing on this date, what's the problem? Is that really sacrificing efficiency? I mean, as long as you get to that hearing date, I mean, I'm sort of arguing the devil's advocate.
No. I think there's a few issues, and there's one I'm involved in now, representing a party. The opposing party wanted to take a few third-party depositions pre-hearing, and I objected. And the arbitrators asked, if you were him, would you want to take those depositions? I said, I know why he wants to take them. But I would just, for instance, I'm going to bring my witnesses to the hearing. He said, well, we're going to allow these couple depositions. So the arbitrators issued the subpoenas, and the witnesses wrote back through counsel. Arbitrators have no authority to enforce these subpoenas. We're disregarding them. We're not producing documents. We're not coming to any depositions. So I thought that would be the end of it. Instead, that litigant started a state court action in Florida to attempt to enforce those pre-hearing subpoenas. One of the litigants moved to dismiss because the action was filed one county over from where the subpoena was served. The court overruled the motion to dismiss, but then editorialized and said, I am allowed to entertain and preside over pre-hearing subpoenas for discovery before an arbitration hearing. So he wrote in the order, preside over. So a state court judge believed that he is going to sit and observe and referee a deposition pre-hearing in an arbitration over which he has little jurisdiction. Solely because of that language, 32 third-party subpoenas came out the next day from opposing counsel for witnesses in California, Texas, Tennessee, Ohio, New York, and Florida. So we had long discussion with the arbitrators, expensive oral hearings with me essentially saying, can we put these in buckets? Like subpoenas that a court could actually enforce. subpoenas that are for people that are 100 miles away from the state court, even though it isn't a district court. Should that dispute be in district court? And, to the arbitrators, each of these jurisdictions addresses this concept differently. We should just go back to everyone bringing their witnesses to the hearing. And that hasn't been decided yet, but there's no way it's cost us less than $150,000 to deal with it. And as you mentioned, Albie, about whether parties could agree, we try. Come on, let's rein this into a certain number of important witnesses, and I won't object. We haven't been able to get to that agreement. So I think that, the idea of fundamental fairness, I'm bothered more by when one party has all the access they want to the third party witness and the other party has none. That bothers me more. So those of us who work on large construction projects, everyone goes poof as soon as the job is finished. So you have 3,000 people working on a project in the Middle East, and it's zero a month after the project is over, and everyone has switched employers and they're on to their next 5 or 6 year long project in a different country. And it's dealt with one way. In the US, if I find that one party has all the access they want to this really important witness, to their documents, to speak with them anytime they want, and the other party wants their deposition, and it's somewhere where a court would enforce it, I'll sign it.
The relationship between the third party witness and the parties to the dispute is obviously important. The other learning point I think that came out of what Tom said is, we talked about the FAA, we talked about Section 7, we're dealing with the FAA, but don't forget, all of the states have their own arbitration laws. Some of them have very different provisions in them than the FAA has. So be mindful of that as another source of laws beyond the scope of what we're talking about, but be aware that they're out there. Zach, you were going to?
No. Preemption's an issue. The FAA's preemption, and courts have come out different ways on this across the board, but whether or not the FAA preempts those state third parties discovery statutes or provisions is a question that's sort of fraught. It's out there as well among the many, many issues. Like I said, it's an onion that you peel back, and more you look at it, the uglier it looks. But I think, Catherine, you were going to say.
Well, I was just going to go back to, I think it's interesting, if you do convene a hearing to get the witness and the testimony, we talked about this a little bit before and you brought it up, how far does that hearing go? There's an indication in Judge Alito's case that in the concurring opinion that you can convene it, get it, and adjourn. And we were talking about that. Is that really what that's for? Or you mentioned, you convene it and then you get the evidence and it's conducted as some part of the merit hearing. And then I think my thought is on that too, then what happens? Do they need to come back for the main event, the main merit hearing? Is that everything in there? So there's a lot that really, because of the, I think, vagueness in the way it's written and the changes that have gone on in society with Zoom and everything else, I think we're kind of left with, you see what happens when you leave lawyers to their own device, then everyone, there's 100 different arguments and they're all pretty good for how this should be handled. But I think the most important thing for an arbitrator to do is think through these issues at the beginning and either get some consensus, get some rules in place, and see if you can nip it in the bud before it gets too far down the line, which may not be possible, like what you said.
Well, sure, because the idea of adjourning is something that I've been seeing more of, more as a litigant. I haven't had to deal with it as an arbitrator, but I've had a matter in which a party was allowed to subpoena a number of third-party witnesses who did not show up for their depositions, but did show up. A couple of them showed up at the hearing. And at the conclusion of evidence, that party said, I subpoenaed 12 third parties, 3 showed up and 9 didn't. And he asked the panel to adjourn the hearing to give him the opportunity to enforce the subpoenas to compel the witnesses to show up at the hearing. It'd have to be a pretty extreme example and the witnesses would have to be awfully important to do that. But imagine putting on your whole case as the claimant and the other side puts on part of his case and then essentially calls a timeout and says, I'm going to go to a combination of state and district judges to force these people to come in and testify. And when I'm finished doing that, we can come back and finish the hearing. Well, in that circumstance, that lawyer probably is not going to move as fast as humanly possible. And now you wind up with a break of an indeterminate period of time, potentially months, before you've put on your whole case. You've gotten to hear half of the other one as the arbitrators are forgetting all the good work you did. The other side comes back in with these other witnesses. I think it's very difficult, but it's an option that's available to arbitrators if they want to do it.
I think the core of the case, or the circuits like the Second Circuit, not the ones that permit pre-hearing discovery, but that don't, is that you only get one bite, right? It's a hearing. That's, it's not a magic that you're creating that I can go out and, as a fiction, create a hearing, then adjourn that, walk away, and that person then shows up again at the hearing under force of a subpoena. I think that's contrary to what the Second Circuit's logic is in terms of their thinking. Different circuits have different ways of thinking about it, but it makes perfect logical sense, and it goes back even to 1925 when Section 7 is written, that bring the person in, hear the evidence that you need to hear as the arbitrator, release the person. They can't be called back. They're done. And I think that's the way they look at it, and not this sort of, we're going to convene something for purposes of discovery, and then you still have the right under the Second Circuit law to bring them in again and compel them to attend. Now, if they come in and attend the second time because somebody calls them, that's a different kind of question, a different issue.
So let me pose this to Albie. So the New York City Bar Association wrote a very, very helpful piece on third-party discovery on Section 7. And they made recommendations as to how that section should be amended and changed. And they didn't follow or recommend that parties of the Congress address or adjust Section 7 to mimic federal court litigation. They actually recommended in the case of litigations for just depositions. They recommended that you have essentially these mini hearings where the arbitrators literally preside, be prepared, and listen to the testimony. So not really depositions, you really are giving live testimony for the arbitrators to assess. And that would be the more appropriate way of giving cause to the spirit of what Section 7 is supposed to be. And when I was talking to Albie about this yesterday or earlier this morning, I asked him, what do you think about that approach? Do you think that really works, or is it really just better, let them take a deposition?
Eric would probably have some very good views on this point as well, but I don't really want to see anybody in Congress, especially the way Congress is today, tinkering with Section 7.
Yeah, fair.
Right, leave Section 2, Section 1, Section 3 of the FAA as they are. Don't touch them. When they add Section 5, when you get to dealing with consumers and employment, and we can do that without doing any harm to what commercial arbitration side of the FAA and international arbitration side of the FAA. That's a way to at least control that issue. But having somebody go in and start to dabble with the language of Section 7, I think, is problematic. I'm not sort of judging which solution is the best. Some of the circuits seem to be taking a convenience look at Section 7 and the pragmatic one and saying, depositions and pre-hearing discovery are part of the American judicial system. So if you're going into arbitration, we're going to think that that's exactly what is contemplated by Section 7, and they are a little beyond what the linguistic language might say on its face. Others, I think, are much more strictly construing the statute and lead to the situation where you conduct a hearing or a mini hearing for the purpose of taking evidence once and for the arbitrators to consider. We're probably at a good point now to transition this a bit into our last topic, which are really the implications of Section 7 of the FAA on international disputes. Zach, I don't know if you want to offer a few thoughts on that.
Sure. So this is probably the more interesting part. We've kind of been talking doctrinally about what the circuits in the United States do. I think I started out this panel talking about the value that American practitioners usually apply to third-party discovery, and how that might not always be the case for non-US practitioners. And in an international arbitration, third-party discovery is limited. It's technically possible. Most, if not all, Institutional international arbitration rules recognize the authority of arbitrators to issue third-party discovery. Certainly the IBA rules, if you're familiar with those, recognize the authority of the arbitrators to order non-parties to produce, provided there's a mechanism in place at law in the seat to give rise to that, to compel a non-party to appear. But I think there's an additional layer of just what the norms are that govern international arbitration that make it fundamentally different. International arbitration is not US litigation. It's not US domestic arbitration either. It is very much a combination of common law and civil law expectations over how you manage a process. And in international arbitration, the norm really is each party comes with their own evidence, presents their case using the documents they have, end of the story. There is no inherent right in international arbitration to discovery. And in fact, the word discovery is very much a bad word in international arbitration. It's really
Information exchange.
Information disclosure. And so, in the scenario, I think Albie and my co-panelists were talking about earlier is you have, a third party really does have access to information that is relevant and material. If you're in an international arbitration, you may not even get access to that third-party witness. You may not get access to those third-party documents because it really isn't the norm. And it's a product of, in large part, not to speak with too broad of a brush, but civil law practitioners do not view discovery and disclosure with a high level of skepticism. And so it's one thing to allow the opposing party to rifle through your own documents, right? That's sort of offensive in its own right? You don't want to show them your bad documents. You want to show them your good documents. It's an entirely other thing to allow a party to rifle through a non-party's documents who have nothing to do with the case, just from a very broad sort of gut level reaction. I think that's what a lot of these practitioners are dealing with, is that they find that concept of sort of rifling through another party's documents to be offensive. And so when you have these third-party discovery issues arising in international arbitrations, you may have an American arbitrator who's used to third-party discovery, is willing to apply limits to it, but still grant it in some limited capacity. But you may also have civil law practitioners. You may have practitioners from Latin America, from Europe, from Africa, from wherever, where third-party discovery isn't the norm. It's viewed very skeptically. You may not get it at all. And so it goes back to the idea of what's the purpose? Is this truth-seeking? Is it efficiency? Is it something else? Is it good, bad? I don't have an answer to that, but I think it sort of raises all of those questions. This approach in international arbitration is fundamentally different than what you see in the United States. And I think Catherine sort of alluded to it, using witness statements, using practices in New Zealand and Australia. You get oftentimes the same result in a very good, effective manner. It's just a different way of looking at the world.
Sure, I agree with all that. I mean, I spend probably half my time at arbitration outside the U.S. and half in, and it is a cultural. I mean, to send it's a cultural thing. The idea that in the U.S. it happens a lot. Again, I'm a construction lawyer. Client will contact us, we'll get involved in a claim, and they'll say our records are garbage on this project. That's okay. We'll get them from everybody else. And you do, and that's how you piece it back together. When a client on a project in Afghanistan says, "Hey, our records are garbage, but who really have good stuff," I stop them. Don't even tell me. Don't even tantalize me, because we're not going to get it. We're not going to get it from anybody. So we're going to have to build our case with what you have, and the other side's going to build their case with what they have. And if there's multiple parties involved, that's different. You'll see other people's information as well. But the concept of rifling through someone else's information who has no dog in the fight is completely, without a better word, foreign in international arbitration.
Catherine, any closing thoughts before I open this up for questions?
Well, I just think, you talked about that organization that ranks countries. I think one of the things that is corporations want, you'll hear in any business talk about when there's shift in interest rates or the political climate, going back to our keynote, is uncertain, is they want certainty. And that's the best thing a business can have. They want to know what it is and proceed from there. So to me, that always reinforces one of the benefits of arbitration is to give a decision. Here's what it is. Here's what you're paying or not. Here's what you get or you don't. And I think that's an important part of giving certainty, going back to the importance of arbitration for commercial and what the benefit was and should be for putting arbitration contracts into your agreement or statements into your agreements.
All right, let's open it up to questions. I don't know if there are any. Dr. Grant. We have a microphone coming around.
I can hear you.
We can hear you. I don't know if it's on or not, but there you go.
Okay, that's on. Yeah, Section 7, obviously, because of the interpretations in various ways in various courts, creates problems for arbitrators. It creates problems for counsel in arbitration. But it seems to me it creates even greater problems for the contract drafters. And Catherine alluded to that. So my question is, suppose you are advising the drafter of a contract who is going to choose a seat in the United States. First question, where should that seat be, keeping in mind that they want to have enough information to make the case go well, but don't want it to go on forever with subpoenas. And second, as Catherine suggested in reading the last part of Section 7, should you also designate specific venue in addition to seat, given the ambiguity of the language?
Who wants to tackle it?
Looking at me.
We're looking at you.
In terms of the seat choice, I don't know if you are going to ever be able to pick a seat that so carefully prevents these areas of confusion from arising. So in a lot of ways it is, at least appears to me, to be a bit of a crapshoot. Maybe you can play around with the edges and pick a seat that might have slightly more or clearer precedent to deal with those issues. I still am very preferential to using New York. I think the New York courts are extremely knowledgeable about arbitration practice. And I think you get usually you get cases that are consistent. And so I tend to prefer New York, though I'm not saying there aren't other jurisdictions that are increasingly becoming more sophisticated. I think you're seeing quite a bit more sophistication in Miami for what you're seeing coming out of Latin America. I think Houston's becoming increasingly more common. But I think at this point, at least in my experience, New York tends to be the preferred seat in that.
I picked New York for a lot for a similar reason. I don't think you can predict whether your future dispute is going to be one in which you're going to want discovery. I think what you can do is you can pick a circuit that has written a lot and is firm and unlikely to change quickly. That's why I think New York is a good spot. I think that if you pick other circuits that are up in the air, you have significantly diminished your ability to just tell your client, if you're the litigant, whether they're going to have third-party discovery, what it's going to be like. In New York, you know.
Yeah, I think that, the better feature that you use to control these issues is picking the arbitrators. You pick someone that you know has certain abilities or a certain view of the world where third-party discovery is used broadly to your advantage, or used very narrowly, or not at all. But I think that's where I think the seat is going to be less of an influence than it is the arbitrators themselves.
I agree with what everyone has said. New York would be my preferred seat, particularly if it's international arbitration. And I prefer strongly, and I disagree with my fellow panelists, I prefer strongly model clauses. You may tinker with them a bit to include, things like the seat, the number of arbitrators, the language of the arbitration, but relatively basic level tinkers. So there's some of the suggested additions that people have made, and even some of the model clauses contain. Because I'm reluctant to take away the flexibility of counsel and the arbitrators to manage the particular dispute that gets before them in a way that makes the most sense for that dispute.
So I'll only say I we have a little, but we're both thinking about different disputes we've been involved in, right? So it gets into how it comes out. But I think if your client says, for instance, listen, I import beef from all over the world, and here's the issues I have. I can't afford if they don't pay or, certain things. I got to get this resolved because I got to know the next contract, the next future, all those things, depending on the situation. In those kind of situations, and depending on what the topic is, obviously, right? I think you want to craft something that you have to consider all the risks. Of course, there's going to be a risk, but you're going to craft something that's going to help the client get that decision and get that money or not, so they can move on. So I think it's important as far as I'm not as wed to New York, only because I think it's where it's the arbitrator. I agree with that strongly. And I think it's things like where those summons or subpoena going to be issued that are going to affect it too. So I'm back to the arbitrator is key. And if you can craft language that gets more often than not what your client wants, I think that's a good bet.
Yeah, picking the arbitrator, I agree, is vital. There's plenty of times when, I'm on panels overseas in which I know a party has picked an American arbitrator because they think that will get them American style discovery and litigation. It's not how it works. It's just not.
Gentleman in the back.
Yeah. Hello, everybody. My name is Brian. I'm a regional relationship manager at Chartered Institute of Arbitrators, the only employee in the arbitration. Thanks for reminding me. Lovely to be here. Thank you. So it's for having me for this session. My question, as an arbitrator, Vegas score should scare you. And what role does Vegas score and credit Vegas score for violation of public policy have in your decision making and whether you're going to grant your
Yeah, so I've never been concerned about vacature at all for a second. And I think I'll say that because I work really hard to be up on the law and know what I should do and shouldn't do and what the bounds are of my authority. I do think, and we discussed this actually earlier this morning, in the US, for whatever reason, as soon as a lawyer doesn't get what they want from you, they say, are you refusing to hear the evidence? Because that's one of those hot button issues that could result in a vacature of an arbitration award. You don't generally get that outside the US. So I think that, I'm mindful to make sure that I'm making decisions that can be supported. And I think that's my best protection. I think that, again, in the US, I can't remember the last case I heard in which at some point someone didn't use one of those buzzwords about how, setting up that if you're going to refuse to hear certain evidence, there's a third party witness that's outside of the country and we can get him on a cell phone for 10 minutes. If you won't let him testify, then, you're refusing to hear evidence. I'm not swayed by that or concerned about it at all.
Thank you for coming, first of all. Second, I'll tell you that Zach and I wrote a paper about due process paranoia about 2 years ago. So I won't summarize our thoughts, but they're set forth there. So that gives everybody something to go look for if you're really bored and need something to sleep by at night. So, John?
Thanks, LB. One comment and then a substantive question. The comment is that I was sitting on a tribunal actually last year. There needed to be a subpoena for a reluctant witness that both parties wanted in Chicago. Arbitration seated in Ohio. It was a virtual hearing. We issued an order deeming that we were in Chicago and then issued a subpoena as if we were in Chicago when we issued the subpoena. And then the other thing relates to the question. And the witness appeared, represented by counsel, first had objected, not going to appear, but ultimately decided, I'm
Don't want to get in trouble.
So we got that evidence. But the question kind of touched upon a subject that was raised with regard to the role of state courts and the state arbitration acts. In this particular case, by the way, the enforcing court would have had to been the Circuit Court of Cook County because it was a non-diversity case. So therefore, federal courts did not have jurisdiction. Just recently affirmed the last couple of weeks by the U.S. Supreme Court. So state courts may well have a role with regard to enforcement of subpoenas. And then secondly, is that as long as the state Arbitration Act is not deemed inconsistent with the FAA, and there is judicial assistance provided in many state statutes, you can proceed through the state court system sometimes.
Yeah, some are very
with regard to that.
some are very specific, like Florida and New York both have very specific arbitration provisions. In the seat in a virtual hearing, I think the best practice has to be you need to specify that seat, that even though it's a location, confirm in your order, whether it's preliminary hearing order or the hearing the order that says you're going to Zoom, that the seat remains whatever was specified at the beginning.
Yeah. You don't want to mess with
Correct.
where the actual seat.
Was the testimony worth it?
Yes.
And the reason I asked that is because sort of a teaching point that if you're the one who's just grinding for this third party testimony and you get it and the arbitrators go, you've probably hurt yourself a little bit in your credibility. And the other thing I comment on before the state court answer is that's really smart. I mean, to basically convince a witness without beating them over the head to come to the hearing and again, during COVID as well, is determining the seat was somewhere else. I think it's ingenious for an important witness. I think it's a good idea. The state court, yeah, I mean, again, there are some of the best judges on the planet are in state court as opposed to federal court. It's sort of like a box of chocolates. Most of us say we prefer to be in federal court, in district court on these kinds of issues. But more and more, I think, based on some of the things that may be spoken about here later, we're going to see state court judges making decisions that are going to be inconsistent in their district on this exact issue.
Any final questions?
We have one that was written in, and I think it's a good one to end on. So CPR has a new initiative promoting the use of a neutral for post-dispute process design to assist the parties in airing and addressing the arbitration process issues to enable the parties to tailor the process with a specific dispute in mind. Do you guys find that useful?
I haven't seen that. I mean, CPR is always doing something a little bit out of the box like that, but I'm not familiar with that.
I haven't either.
Yeah.
I know they have it, but I haven't seen it.
It seems to me that depending on when they're doing it in the process,
Right.
it really may impinge upon the role of the arbitrators in styling what that case is going to look like going forward. But CPR is initially non-administered, so if they're just assisting them in structuring the way they want the arbitration, those kind of things may be a different story. Although they have administered arbitration now as well. Well, thanks everyone. Really appreciate your time and attention on the panel.
Thank you.
A lot with Section 1782. So I'll introduce it with an anecdote here, is that 25 years ago when I was in law school, it wasn't taught. Wasn't even a footnote in a textbook. It wasn't even mentioned, even though it had been on the books for 40 years or so. I remember I was a senior associate and I had filed a Section 1782 action. This was 2008 or so. It's a relatively small Section 1782 action. I found myself before a magistrate judge in the Southern District of Texas, I believe, with the 1782 action. And my opposing counsel got up immediately and was absolutely indignant that his client had gotten the subpoena. And his first comment to the judge was, "Your Honor, you mean to tell me that you can order discovery in aid of a foreign litigation? You've got to be kidding me." And the judge looked to me and said, "Well, what do you have to say about that?" And I stood up, I opened up the USC code section 28 of the USC section 1782 and read it. I just read it to the judge and it said, "The district court of the district in which a person resides or is found may order him to give his testimony or statement, or to produce a document or other thing for use in a proceeding in a foreign or international tribunal, including a criminal investigation conducted before formal accusation. The order may be made pursuant to a letter rogatory issued or request made by a foreign or international tribunal or upon the application of any interested person." Pretty simple, pretty basic. I won that argument by simply reading the statute. But the point of the anecdote is there's a big part of the bar 15 years ago who didn't even know that Section 1782 existed. Now, these cases have exploded, I think, in the past 15, 20 years. And why is that? It's a case that I spent a good part of my life on, was the Chevron Ecuador case, which really blew the situation wide open with respect to Section 1782. There was once a point where you'd go to international law conferences and you could take a poll who's worked on the Chevron Ecuador case, and like 2/3 of the lawyers in the room would raise their hand. It was a $19 billion case, and there was a litigation in Ecuador, an arbitration in The Hague, and about 100 Section 782 applications around the United States. Well, it gave rise to a lot of jurisprudence and a lot of awareness of what this statute was. So everyone started using it, right? And like everything, us lawyers, we kill what we love, right? By mangling it and trying to fit it into a lot of different situations. A foreign or international tribunal, that's what you need here to get discovery under Section 1782. And that's what we're going to talk about today. Getting this sort of discovery for a foreign litigation is simple, easy. We don't even have to really have a discussion about it. That happens all the time. What has happened is a lot of courts have been issuing subpoenas in aid of arbitration, construing foreign or international tribunal as an arbitral tribunal. This issue is now before the U.S. Supreme Court. It was argued about a month ago. We'll get a decision in June. And that's what we're going to talk about today, is we're going to talk about Section 1782 really as it applies to international arbitration. So we've got a great panel here to talk about it. I'm going to introduce them and just sort of let them take it away. First here, we have Professor Andrea Wang from the University of Pennsylvania's Carey School of Law. She teaches in the fields of civil procedure and transnational litigation with a focus on the relationship between U.S. and Chinese courts. Before joining the Penn Law faculty, she was the Thomas C. Gray Fellow at Stanford Law School and clerked for Judge McEwen on the United States Court of Appeals for the Ninth Circuit. She practiced in the litigation groups of Latham and Watkins and Vincent and Elkins before joining the academy. To her left is Carolyn Edsel Littleton. She's a partner in the global disputes practice at Jones Day in Washington, D.C. I've had the pleasure of working with Caroline for maybe almost a decade on a number of big commercial and mostly investment arbitrations. Caroline and I worked together before I left the firm last year. Before joining Jones Day, Caroline clerked for Chief Justice John Roberts from the United States Supreme Court and Justice Kavanaugh when he was on the D.C. Circuit. Our third panelist is John Pinney. John chairs the International Practice Group at Graydon in Cincinnati. Over the past 30 years, he has served as lead trial lawyer in complex litigation and arbitration cases around the world. And he's an adjunct professor of law at the University of Cincinnati College of Law, teaching courses on international commercial arbitration. So I think today the plan is Andrea, you're going to talk about sort of the history of 1782 and the Supreme Court decisions that have given rise to the current practice and to the current discord under the law. So
yeah. Thank you so much. Thank you for putting together this panel and for inviting me. And it's great to be able to spend some time at the law school here. I come to this subject from an academic perspective. As Chuck mentioned, I teach civil procedure. I'm sure each and every one of you's favorite subjects. And a few years ago, I did the only systematic study of 1782, looking at over 3,000 requests that were filed between Intel, the Supreme Court case dealing with the statute, which I'll talk about in a few minutes, and 2017. So I looked at a period of 2005 to 2017. And so I'll share with you some of the background on Section 1782, what Intel told us, and then ultimately, what we've seen in lower courts. So I'll start with a bit of history. 1782 is not the first statute in the U.S. that's provided discovery assistance to other countries. We actually have a very long history of doing that, dating back over a century. It used to be a fairly narrow provision, and over time, it's gotten broader and broader. Most prominently after World War II, there were more international transactions, and U.S. lawyers had gotten used to very broad discovery in the U.S. under the Federal Rules of Civil Procedure. They were quite frustrated when they went abroad and couldn't get the same discovery. So they lobbied for better access to discovery abroad, and the theory was that if the U.S. provides generous discovery assistance to other countries, they will reciprocate and do the same for the US. Of course, no, not a single country has done that, but let's just set that aside for now. And a curious detail about the statute is that it was written by a commission that was headed by a law professor at Columbia, Hans Smit, and they actually ran out of money halfway through writing the statute, and it ended up being funded by the Carnegie Corporation. So there's some debate about how much Hans Smit's perspective on this question should matter. He was the primary author of the statute, and after the statute came out, he wrote an article saying that he thought that arbitral tribunals should come under the ambit of the statute. My personal opinion is I'm not actually convinced that Hans Smit, internal thinking really matters here. It was Congress that passed the statute. And so it is, if we're going to look at intent at all, it should be Congress's intent. And if they didn't think about arbitral tribunals at all, then that's what we're left with. Just in terms of the statute, Chuck read to you the statute, so I won't read it in detail, but let me just give you the cliff notes for the statute in my mind in terms of the most significant details. So the important thing here is that the statute says that the district court may order discovery for, quote, use in a proceeding in a foreign or international tribunal. And it's really, the question is, in the Supreme Court case, what does foreign or international tribunal mean? It says the request can come from the tribunal itself, or it can come from, quote, any interested person. That's a detail I'll get into in a bit. And it can prescribe the procedure of the foreign tribunal, or by default, it's going to be under the federal rules of civil procedure. So it's actually quite a remarkable statute in my mind, because it allows US federal judges to have a hand in foreign disputes. And that involvement crosses international borders, it crosses legal systems, it crosses different systems of procedure. And most importantly here is the fact that the US system for discovery is quite exceptional. It is the broadest discovery that we see anywhere in the world. So the Supreme Court has taken up this statute just once in its history, and it's in a case called Intel versus Advanced Micro Devices. This case was heard and was decided in 2004. And in it, the Supreme Court took an astonishingly broad interpretation of the statute. Just to give you a tiny bit of background, so this case was, the foreign proceeding there was a regulatory investigation before the European Commission, which is a regulatory agency that oversees antitrust. There was a complaint that Advanced Micro Devices, AMD, let's just call it AMD. AMD made a complaint to the European Commission, and so the European Commission was investigating in antitrust issues involving Intel. Now, AMD went to the European Commission and said, why don't you ask Intel to produce this information? The European Commission said, no, we're not going to do that. So then AMD came to the US, asked the Northern District of California for the same information that the European Commission had said it didn't want. So that's the case that came before the Supreme Court. And there the European Commission said, not interested. We have our own process that you're going to disturb. You're going to siphon resources away when we have to look at all this documents. So they didn't want it. And they actually submitted an amicus brief and participated in an oral argument. So the Supreme Court, held four primary things. The first thing is that the request can be brought by not only parties, but also by non-parties with procedural rights. So that's how they interpreted any interested party. The Supreme Court then said that the foreign tribunal can be any court, any tribunal, and it includes any first instance decision maker. So that includes regulatory agencies. It then said that you can get discovery before the case is even filed. You can get pre-filing discovery as long as the proceeding is within reasonable contemplation. And then lastly, it said there is no foreign discoverability rule, meaning that even if the discovery that you're seeking is not permitted in the foreign proceeding, you can still ask for it. So note here that we're actually talking about discovery that's broader than what is permitted in the US under the federal rules of civil procedure. And instead of holding any of these bright line rules, the Supreme Court said, well, here's 4 discretionary factors that federal judges that you should consider when you're making these decisions. And the 2 primary factors that the Supreme Court set out are 1, whether the foreign tribunal is receptive to US discovery assistance, and 2, whether the request is an attempt to circumvent foreign discovery rules. So those are the 2 that I'm going to focus on here. So in my study, I didn't collect data pre-Intel, but as Chuck mentioned, I think it's a pretty safe bet that the use of 1782 was much lower pre-Intel. What I did find is that between 2005 and 2017, the use of 1782 quadrupled. So now we're seeing hundreds of requests before federal district courts every year. It's really become a bit of a cottage industry. Nearly every large law firm, and even any law firm really that does transnational litigation or arbitration, uses it. And law firms have called it a backdoor to discovery, a powerful strategic tool, a tool that you're going to ignore at your own peril. One of the most interesting things I found in my research was this PowerPoint presentation that a law firm gave in Russia. And one of the slides said, you are invited to come to the US for discovery. So they were essentially doing PR for 1782 abroad. And the current usage is just extraordinarily broad. We're seeing requests from every single continent, maybe not Antarctica, but every single continent, Africa, Middle East, South America, Asia. They come from civil law countries, common law countries. They come from tribunals themselves, which, these are less controversial because if the request comes from the tribunal, they obviously are receptive. But they also come from private parties. In fact, the number that are coming from private parties is now more than the number that are coming from tribunals. And these requests fall under many categories. There's pre-filing requests, there's requests for arbitrations, commercial arbitrations, and investment arbitrations. And there are requests that are seeking discovery for multiple proceedings at the same time. And when there are requests for multiple proceedings, federal judges tend to say, if one of the proceedings falls under the ambit for an ambit of 1782, then the other ones can kind of just come in with it. So you can see some of the issues that come up in the way that these requests are being made. And I think most importantly here, they tend to target third parties. Over 80% of these requests are targeting third parties, and they're granted at a very, very high rate. About 90% for requests that are coming from parties, and even higher if we take a look at the overall rate. About 10% of these requests are coming from arbitral tribunals. So we're talking about mostly commercial arbitrations, but also some investment arbitrations. Just in terms of what this looks like in practice, we're talking about a party coming to a federal state judge. They ask, and these requests are almost always ex parte. They say to the judge, I'm seeking discovery from this third party. The judge grants it because there's nobody opposing it. The third party gets subpoenaed. And then once they're subpoenaed, they find out about the request. So now they have to move in to quash the request. And there are times when the third party actually doesn't dispute it at all because it's not necessarily in their interest to spend a lot of money and resources to oppose the request. They're not participating in the foreign tribunal or foreign proceeding. So sometimes they just hand it over. And what ultimately ends up happening is that the judge is left asking these questions. Is the foreign tribunal receptive to this discovery? Is this an attempt to circumvent foreign procedural rules? And of course, the judge now must listen to the third party make these arguments. The third party usually doesn't know that much about the foreign proceeding. They may pull in the opposing party, which would give them more information. But often we see judges trying to make these decisions with so little information. I've seen cases where the judge doesn't know if the foreign proceeding is criminal or civil. They don't know if a similar request has already been made. The third party is simply not in a good position to be offering this information. And so with these critical factors, the judge tends to hold that if there is not authoritative proof that the foreign tribunal is not receptive, we're going to decide that the foreign tribunal is receptive. So that's where we are with the statute. And now before the Supreme Court is the specific question with respect to arbitral tribunals. And, if they hold that these arbitral tribunals are beyond the scope of 1782, then that carves that set of cases out of 1782, but we still have the same dynamics with respect to the rest of the requests. So I'll stop there and hand it over.
I think it's a good time to now say, like, with that basis, where did the current cases come from? And what are the current cases that are before the court?
Yeah, and so I wanted to focus in on commercial arbitration at the beginning of my remarks because that gave rise to the circuit split. And basically the split is very recent. There were two pre-Intel cases in circuit courts discussing whether 1782 is available in aid of international commercial arbitration. And the first one was NBC versus Bear Stearns. It was in the Second Circuit and it was January 1999. And the court ended up holding that the term foreign or international tribunal was ambiguous on its face. It wasn't clear enough looking at dictionary definitions and ordinary usage, whether that just meant judicial tribunals abroad or also arbitral tribunals. So the Second Circuit moved on to look at the legislative history and the purpose, and they found in the legislative history, in particular in the House and Senate reports, that the congressman had in mind only governmental entities. And a predecessor statute, Section 270, that was incorporated into 1782 in the 1964 amendments was all about intergovernmental tribunals. And so according to the Second Circuit, there was a real intergovernmental focus to 1782, and it was not available in aid of private commercial arbitrations abroad. Just 2 months later, the Fifth Circuit weighed in Kazakhstan versus Biederman, and they basically said, we adopt the Second Circuit's position here. The statute is ambiguous. We're going to look at its background and purpose. We agree that it does not extend to private commercial arbitrations abroad. The Fifth Circuit also noted a potential conflict with Section 7 of the FAA. If you look at that section, it has very defined terms. They are not the same in 1782, and did Congress really intend a conflict between the two of them with respect to international commercial arbitration? The Fifth Circuit indicated no. And that's where things stood at the circuit court level for a really long time. But then you had Intel in 2004, and then it was the Sixth Circuit in 2019 that went the other way. And it was the First Circuit Court case to do so. They held that Section 1782 was available to provide discovery in aid of international commercial arbitrations. And according to the Sixth Circuit, they started out by looking at dictionary definitions, and they found both broad and narrow definitions in 1964 era dictionaries. Some definitions really did focus on judges in foreign countries, but some definitions were much broader. But then they moved on to contemporary legal writing, both scholarly commentary and court decisions at the time. And there they found that the word tribunal has long been used to encompass arbitral panels. In looking at the context and structure of the statute, they found no reason to narrow 1782 to exclude arbitral panels. And they criticized the Second and Fifth Circuits for jumping to legislative history too quickly. When the Sixth Circuit looked at the legislative history, they found a general desire to expand the reach of the statute. And for all of those reasons, it was the Sixth Circuit that held in 2019, you can invoke 1782 and get discovery in aid of international commercial arbitrations. The Fourth Circuit weighed in next, and that was 2020. So it's really, really recent here. And that case was between Servotronics and Boeing. And I emphasize the party names because they had another case in the Seventh Circuit that I'll talk about in just a minute. But that case involved a commercial arbitration seated in England. And the Fourth Circuit found in pretty general terms that the 1964 amendments to 1782 manifested a congressional policy to increase assistance to foreign courts and tribunals. It was a desire to expand the statute, and that expansion encompassed international commercial arbitrations. And interestingly, the Fourth Circuit said that even if we were to require that the foreign tribunal be acting with the authority of the state, This foreign tribunal was acting with the authority of the state because it was operating under the auspices of the United Kingdom's Arbitration Act. So even commercial arbitration in England has the imprimatur of the government because this statute governs it, and that was enough for the Fourth Circuit. Like I hinted just a few minutes ago, the Seventh Circuit came out the other way in a case involving the same parties. It was that same arbitration seated in England, but for the Seventh Circuit, they said that foreign arbitral panel was not a foreign tribunal as defined in 1782. The Seventh Circuit relied on the statutory context, in particular nearby provisions, 1696, which refers to service of process between foreign countries, and 1781, which refers to letters rogatory between foreign countries. To the Seventh Circuit, those were matters of comity between governments, suggesting that the word tribunal in 1782 was a governmental tribunal and not this panel in England. So it was out of this decision that a cert petition was granted by the Supreme Court. And that case was fully briefed. The Solicitor General even filed an amicus brief, taking the position that 1782 does not extend to private commercial arbitration, but also devoting an entire section at the end towards warning the Supreme Court, please don't say anything in this case that would have an impact on investor state arbitration, because we, as the Solicitor General's office, strongly feel that 1782 does not apply to investor state arbitrations. Now, I just focused on commercial arbitration because that gave rise to the circuit split. In the background, there really wasn't much disagreement about 1782 as applied to investor state arbitrations. It was more or less generally agreed that 1782 was available in aid of investor state arbitrations. And for that reason, when you look at the restatement on international commercial and investor state arbitration, the final draft was approved in 2019. They came out taking the position that 1782 is available in aid of investor state arbitration and should be available in aid of private commercial arbitration too, because there wasn't much disagreement there. But when the Solicitor General weighed in, he seems to have changed the landscape, because that Servotronics v. Boeing case that made its way to the Supreme Court settled and was dismissed by agreement of the parties right before oral argument. But there were new cases in the courts because there are so many these days, and two new petitions presented themselves to the Supreme Court in very short order. One presented the same question that the court had already taken up, namely, can you invoke 1782 in aid of private commercial arbitration? But the other petition raised the question highlighted by the Solicitor General, can you use 1782 in aid of investor state arbitration? And I think the Supreme Court, in light of the Solicitor General's brief, decided they should weigh in on that question as well. So the court granted both, they consolidated the cases, and they were heard together back in March. And it's very interesting how all of this played out. You know, if the Servotronics case hadn't settled, the court would have answered one question only and maybe been careful about what it said about investor state arbitration. But because the Solicitor General signaled that investor state arbitration was a key question, and given the background settlement, the court was able to have a do-over, a second chance to grant two petitions presenting the two different questions at the same time. And that's where we find ourselves now. The court will weigh in by June.
So before we get to John to discuss some of the practicalities of these cases, I want to ask you, Caroline, what's the difference between commercial and investor state arbitration? Where have parties in the courts articulated a difference on why one should be treated differently? Mm-hmm.
I think from the Supreme Court's perspective, as best I could tell from oral argument, a key difference is when 1782 was amended in 1964. There were two historical examples in the minds of Congress. One was a United States-Canada Claims Tribunal, and another was a United States-Germany Claims Tribunal. They were established by the two countries. The tribunals were created by the two countries, and both of those tribunals ended up needing evidence. And predecessors to 1782 came into existence to allow those tribunals to get evidence. And so there's really no question that 1782, as amended in 1964, was intended to reach arbitral tribunals like that. And the question is, where do you draw the line beyond that? Does it sweep in investor state arbitration, which does have a state element? Does it sweep in commercial arbitration? which is governed by acts like the United Kingdom's Arbitration Act, but that's a far more removed government element. So I think that's why it's a question of where do you draw the line, and the investor state arbitrations are closer to the historical precedent than the commercial arbitrations are. But it will be a difficult exercise for the court, I think, to figure out where to draw the line.
And do you think, has the issue come up about, drawing this line? How about state to state courts?
Mhm.
How about the ICJ?
Mhm.
How about how about, a state to state investor state arbitration, which there have been a few.
Yeah, and Justices Kagan and Sotomayor asked that question at oral argument, and the advocate of whom they asked the question declined to answer because he said that's not this case. That wasn't the U.S.-Germany tribunal, and it's not this case. Maybe it's definitely included in 1782, maybe it's not, but you don't have to answer the question. I mean, I think under the historical precedents and the advocate's own position, that very well maybe encompass state to state, because you heard the advocate saying that if there is a standing authority created by governments and exercising authority conferred by the governments, that counts.
Mhm.
And so if the court adopts that definition, some of these very well may count. But for that advocate, his position was that if you have an investor state arbitration, there's no agreement to arbitrate until the investor accepts, and the investor then appoints the arbitrator. There's no standing authority created by the treaty itself. It's, ad hoc, and it's many additional layers removed from governments themselves.
So a question to both of you is, were either of you surprised by the stridentness of the United States' position against applying 1782 in the arbitration writ large context? It was slightly surprising to me. I mean, here in the investor state context, the United States finds itself more often having claimants that are American as opposed to being hit with investor state claims on its own end. Were you surprised by the US's position?
I was surprised in part because they didn't seem at all interested in limiting Section 1782's interpretation back in 2004.
Right.
They argued for an extremely broad interpretation, which was the one that the Supreme Court took up. And also for the reason you're bringing up, Chuck, which is that it doesn't seem like the right incentives are in place.
Right.
So I was quite surprised. I'm not sure exactly what the thinking is behind it.
Yeah. Same.
Yeah, I mean, I was surprised that they reached out to address the investor state context in a case stemming from commercial arbitrations.
Yeah.
And that suggests to me maybe the State Department was heavily involved. I mean, of course, the State Department was involved. And you do see in the briefs and at oral argument this concern from the government that the expectations of the United States as treaty partners will be disrupted by this sudden access to U.S. discovery that arguably those treaty partners did not have at the time they agreed to the treaty. But what you don't see in the briefs, oral or argument, is the government recognizing that those treaty partners use 1782. And the advocate on the other side pointed that out. He said Turkey and Ecuador have made use of 1782 in U.S. courts. So it's not like it's a one-sided thing. I think the other thing that was really emphasized by the Solicitor General at oral argument is that Section 7 of the FAA represents Congress thinking about discovery in the arbitral context specifically. 1782 is not that. However, it is interpreted by the court. There's no indication on its face or even in the history that Congress fully contemplated how it should apply to arbitration. Should it be able to be invoked before an arbitration is begun? That was not carefully considered in the 1782 context. So you really hear the Solicitor General saying, we just think Congress should have an opportunity to think about arbitration specifically when it comes to allowing U.S. discovery for arbitrations abroad. And I guess that's how they came to reason to their position.
One small thing that I thought, I don't know how much this played into it, but when Servotronics initially came up, and I guess even so now, there was an interim Solicitor General. And when I first inquired, I heard that they weren't actually planning on writing an amicus at all.
Mm-hmm.
So I don't know if the position that's now being taken somehow to do with, this change in leadership, or I'm not sure what was happening.
Or maybe just the change in perception towards investor state arbitration is taking a sort of a paradigm shift a bit that is making the U.S. government say, hey, we may not want this in an investor state situation. John, to you. So you wrote an amicus brief in the
I
current
did.
case, and Andrea did as well. And you're going to talk to us a bit about the pros and cons of the decision that may come out, and also your position on what things that we just.
Let me just chime in
Yeah,
on a couple
please.
of the points that were made, because I think they really are fascinating. Because I did write an amicus brief for the CPR Institute with respect to both Servitronics and the Alex Partners case. And I'll mention those a little bit more specifically as I go along. But the key interest of the CPR Institute was, let's get the damn thing decided and not have a circuit split where everybody spends all their time litigating over the jurisdictional issues and spending huge amounts of money just over that. So as a practical matter, this has been an issue that has been boiling over. But going back to why the Solicitor General took the position that he or she did at the time, the issue, my sense was at the time Servitronics came up, is that they intellectually could not draw a distinction between investor-state arbitration tribunals, particularly the kind that arose in the Alex Partners case, because it was really an unsuitable arbitration with private arbitrators. They weren't paid by the government. They were chosen in the typical way of each side chooses one, and then they choose a president or chair of the tribunal. So it was a stretch to think that was something that was really had the imprimatur of government or the state in terms of how it was constituted. And they couldn't draw a distinction between that and private international arbitrations. That's my take as to why they asserted the position they did. And frankly, I think my reading tea leaves is that the court is going to find that there's no important distinction. So they're going to go one way or the other. Which way they're going to go, I don't know. There was a blog that says oral argument in the ZF automotive generates more confusion than clarity on the availability of U.S. discovery for use in international arbitration. It was an interesting arbitration or oral argument to listen to. And perhaps even looking at the transcript made it even more perplexing to try to figure out which way the court was going to go. And I'm not going to go into a lot of detail on that. But my principal focus is just to kind of put this all into some context. And frankly, it is something that is going to echo what you heard from the first panel in a significant way, in the sense is, what's arbitration all about? How does it differ from litigation? And especially in the international context, because in the international context, as was alluded to the earlier session, is that we have kind of an outpost of the United States that has made policy decisions that finding the last shred of relevant evidence is of significance in fairly and justly resolving disputes. That's not the policy decisions throughout most of the rest of the world. And there's a gradation, with common law countries generally allowing more discovery, if you want to call it that, than civil law jurisdictions. But in civil law jurisdictions, under the inquisitional systems, that the judge is responsible basically to gather the evidence, because there is virtually no cross-examination. Witness evidence is largely disregarded, or at least not given very much weight, and documentary evidence produced by a party's own file is really the paramount way that litigation is conducted throughout the civil law world. The point is that parties choose arbitration because they have to bridge the gap between the expectations of parties in one country, one system, and the expectations of parties in another. And as a consequence, international arbitration has developed somewhat as a hybrid, and importantly, has developed so that those expectations can be at least ameliorated and dealt with in a manner where parties will ultimately feel that this is a reasonable and appropriate way of resolving the dispute. So we bring this into the context where Section 1782 allows parties to disputes, and if it's in a court, and I've just had a very significant one with a proceeding in Saudi Arabia, where one of the parties wanted to get substantial evidence from a U.S. party. Boy, that was really something for the Saudis to think that somebody would trace off to the U.S. courts, engage in extensive litigation to secure hundreds of documents, if not thousands of documents. But the point is that in arbitration, the parties aren't expecting that. So the key question is, well, what is the role of 1782? And I'm going to divide my comments really into two levels of discussion. One is, what are the legal arguments with regard to interpretation of the statute? And then secondly, what are the policy issues with regard to the appropriateness of U.S. courts having authority to assist foreign tribunals, and in this case, arbitral tribunals, and gathering evidence for use in those tribunals. First, with regard to the legal arguments, it focuses on whether an international arbitral tribunal is or is not a, quote, foreign or international tribunal, as that phrase is used in Section 1782. Andrea read the statute, or maybe I guess it was Chuck that read the statute. So the Supreme Court is being faced with the issue is, how does one interpret that phrase? And then, as I mentioned, secondly, we'll talk about the policy issues. On the legal arguments, the case garnered 12 amicus briefs, and they were roughly evenly split, with some in favor, some against. And a few saying in favor of neither party, but if the court grants it, be sure you give appropriate weight to the tribunal's exercise of authority, and have that as a key factor for U.S. District Courts discretionary under either the Intel rule or modified Intel discretionary factors. The arguments in favor centered on the single word tribunal, and the arguments against focused on the phrase foreign or international tribunal, and trying to say, as was suggested or in the Sixth Circuit case, Abdul Latif Jamil versus FedEx, decided in 2019 by a then recently appointed circuit judge by the name of John Bush. He went to defining how the word tribunal was used in 1964. And other sources, from dictionary definitions to court decisions and the like. And he concluded that tribunal had frequently been used to refer to international arbitration tribunals. By the way, as a footnote, and as pointed out by the Solicitor General's amicus brief, is that investment arbitration didn't really exist back in 1964. And so there was no consideration as to investment arbitral tribunals back then. there has been subsequent support in the briefs with regard to the interpretation of the word tribunal by citing the Bostock versus Clayton County case, which was the Title VII gay sex case, which dealt with discrimination against somebody who was homosexual, and whether or not the word sex would include that kind of discrimination within the scope of Title VII. And the court said, yes, it did, because of kind of the original meaning of the language used by Congress. It was not insignificant also to the proponents of including 1782 for arbitral tribunals was the role of Professor Hans Schmidt, as Caroline was suggesting. But there's really an anecdote that has some significance with regard to Professor Schmidt, because the author of the Intel decision was the late Ruth Bader Ginsburg, who happened to be a young associate professor, assistant professor at Columbia, working with Professor Schmidt and in 1964. And in fact, the Intel decision had a footnote citing to Schmidt's 1965 Columbia Law Review article, where he referred to 1782's definition of tribunal as included arbitral tribunals. So there, but Justice Ginsburg, of course, is no longer with the court, so that probably is not something that is significant for the current case. But nonetheless, I thought fascinating and interesting. On the other hand, the opponents, as I mentioned, focused on the entirety of the phrase. And by doing so, they're suggesting that the word foreign connected with the word tribunal has a connotation of some kind of state or governmental authority that's being exercised. And they even came up with a survey conducted with regard to the use of or non-use of foreign tribunals and the like to support their position. They at oral argument, each of the points for both sides, I thought were effectively presented. And as I mentioned, leading the blog to conclude that there was more confusion than clarity that came out of it. But I want to focus a little bit on the arguments of Assistant Solicitor General Needler, who was arguing for the Solicitor General's office in the government at the case. And he, I think, was not particularly effective in the first part of his arguments, but he got traction when he started talking about the concept of comity and the relationships between the United States and other countries, and the concern about the effect of U.S. district courts meddling in the international business disputes of other parties involved in international arbitration. And I think he was touching upon both the reasonable expectations of governments, but also of parties within those other countries. As we were talking about earlier, because the U.S. is such a outlier in terms of the scope of disclosures or discovery, is that other parties, unless they're knowledgeable with regard to U.S. processes, really are not expecting, when they agree to arbitration, that they are buying into the possibility of significant litigation in U.S. courts just to gather evidence with regard to their cases. In fact, one can make a strong argument that they chose arbitrations to stay out of the U.S. courts. So that discussion with Assistant Solicitor General Needler triggered in my mind a key point that seemed to get some traction with the justices, is that if we have a statute that has some ambiguity, And these are key policy issues that are important to address. That why don't we defer this to Congress and send it back to Congress, let them grapple with it and decide it instead of by fiat, decide whether it does or whether it doesn't. And, you know, that I'm not sure how the court's going to come out, and it wasn't clear as to which justices lined up with that view, but there certainly was some expression by particularly Gorsuch and a couple other of the justices. So there was no clear direction about where the court was going to go. But let me briefly touch upon some of the pros and cons of the policy issues, which I've generally alluded to already. But in terms of the pros, if one assumes that the goal of any dispute resolution system is to achieve justice, that is a fair outcome based upon evidence, then a procedure that allows a party to obtain relevant material evidence, especially from third parties, is a desired attribute, provided that the cost of obtaining that evidence is reasonable and proportional to what's in dispute, the amount in controversy that's in dispute. And in theory, that's what the Intel factors in 1782 decision by the Supreme Court in 2004 was striving for. Therefore, if such evidence is only available in litigation, it may be a major deficiency in a process of arbitration and consequently lead to results that are, in an objective sense, unfair. But on the other side, and this was talked about earlier in the earlier session, is that arbitration is supposed to be more efficient, more speedy, and more cost effective. And what we've seen in the 1782 litigation, whether it's dealing with courts or tribunals other than arbitration tribunals, and especially in where the jurisdiction issues were in controversy and arbitration especially, there have been huge expenses for parties to try to get evidence, not just because the third parties are reluctant to produce it, but also because it is a collateral issue that nobody knows for sure what the materiality of the evidence might be before you have it. And as a consequence, a reasonably strong argument can be made is that international arbitration works just fine. Let's not mess it up by sending everybody to the US courts. And I'm going to just drop a quick footnote, is that the evidence that's potentially available under 1782 is not only the evidence that the particular third party subpoenaed might physically have at wherever its principal office is, but the federal rules of civil procedure are effectively adopted by 1782, and therefore any documents that are within the possession, custody, or control of the subpoenaed party are theoretically available, potentially without geographic limitation. There was a Second Circuit case, Valley Ruiz, that was decided, I think, about 3 years ago, that basically said is that the world is open for 1782 discovery. So that's another reason that gives some caution. Footnote, by the way, I've availed myself of that in not arbitration cases, but nonetheless, it's significant. And so the bottom line is, and I'll conclude with this, is that these competing policy issues
do give some credence to the suggestion at oral argument that Congress ought to weigh in on this topic. The last thing, just to kind of pull this all together, is that the two cases that were argued before the Supreme Court, the first one is ZF Automotive versus Luxor, and it involved a matter that was pre-arbitration, that the case was filed in Detroit, which is in the Sixth Circuit, and the petitioner in the case, which was Luxor, which I think was a Chinese-owned company, but it had a contract with ZF's parent in Germany and had an arbitration provision with the German Arbitration Institute to be the administrator of any arbitration. Well, knowing that it would be very unlikely to get any significant discovery from the other side, is that Luxor chose to bring an action in Detroit against the US subsidiary of ZF. And the district court in Detroit, but with a decision by the magistrate judge initially, granted it on the basis of the Sixth Circuit's decision saying 1782 applies to international arbitrations, even before the arbitration was commenced. And then through a very unusual, rare procedure is that ZF appealed to the Sixth Circuit, but knowing that the Sixth Circuit's precedent was against him, they asked for a petition of certiorari before judgment. And it happened to fall right when Servotronics was dismissed. So the Supreme Court was primed to, okay, well, we got another case, and they're actually, because of the litigation, it takes a long time for cases to percolate through the system at great expense. And then there was the Alex Partners case, which was in this time interesting because it was a investor state arbitration where the investor was Russian. And it was a bilateral investment treaty between Russia and Lithuania. And the reason that the 1782 proceeding was sought by the investor is that a New York consultancy was involved and had given opinions to the Lithuanian government with regard to an insolvency. So that's how that case. But going back to a question that you asked, Chuck, is the difference between investor state and commercial arbitration is that the Second Circuit, which had decided the NBC case and had reaffirmed the NBC case in a case called Guao just a year earlier, ruled in favor of discovery in the investor state case, saying that there was sufficient state involvement or governmental involvement in an investment treaty case. So you had two panels of the Second Circuit kind of going different directions. They said they were consistent with one another, but it's hard to fathom that. So those are the cases that made it to the Supreme Court. And we'll all be sitting on the edge of our chair sometime in, I think, early June. I don't think they'll wait to the last day. But so
Caroline, Andrea, thoughts on what the Supreme Court's going to do? I have a few questions I want to ask, but I wanted to ask that first.
No, it's hard to say what the court will do in its entirety because, Justice Thomas wasn't there for the oral argument. Justice Alito didn't ask any questions. Justice Barrett said like two things. I do have some sense what individual justices might be thinking in part, but in terms of how they all coalesce together, I'm not sure. Justice Gorsuch was very clear that in 1964, the word tribunal did not mean arbitration and it should be sent back to Congress. Justice Breyer started out the oral argument thinking we should just say that courts should defer to the arbitrators. But after hearing from Mr. Needler, who represented the Solicitor General's office, he started to move towards Justice Gorsuch's position of, maybe we should let Congress weigh in on this. Justices Kagan and Sotomayor were very focused on how if at all, to distinguish investor state arbitration from these intergovernmental tribunals. I think they're struggling with seeing that. I think it was Justice Sotomayor or maybe Justice Kagan who asked a question about how, well, hasn't the state delegated its authority to choose an arbitrator to the investor? And why is that meaningfully different? And I'm not sure they were satisfied by the answers. Justice Kavanaugh was very focused on how to define governmental. So if you do draw a line anywhere, how do you define that line such that it is focused at a point in time? And Justice Kavanaugh was also focused on broader principles of statutory interpretation going forward. Do you look at a word alone or do you look at a phrase? The chief seemed pretty skeptical of the petitioners on both sides. Given his questions, he may have entered oral argument with the view that tribunal in 1964 meant arbitration. Like, even if they weren't talking about it in the legislative history, that's what we've always called an arbitral tribunal. I don't know if that really was his view or if he will stick to it, but that's what some of his questions suggested. But one thing about the Second Circuit case is that In re Guo case that reaffirmed NBC and said that the private arbitration in China did not count. The CTAC arbitral institution was founded by the Chinese government. Nevertheless, the Second Circuit said this isn't governmental, it doesn't count. But then when the Second Circuit reviewed the Alex Partners case, they said, the functional attributes of this are more like government to government because there's a treaty involved. And really for the Second Circuit there, it seemed to come down to the treaty. So I agree with you, it's confusing. And it's also an example that really highlights how hard I think it will be for the court to draw a line.
Yep.
Okay. Yeah, I agree. It's going to be really hard. I fully agree with the blog post about it being more confusing than clarifying, because I wrote that blog post. I don't think the statutory language gives any traction to answer the question. I do think, there seemed to be movement towards these two alternative paths. One, which is, let's just throw it back to Congress, which makes sense. It doesn't seem to me that Congress, not only did they not really think about what what tribunal meant back in 1964, it's not clear to me that they thought about the statute at all. They were given this language by the commission. When I looked back at the history, they just summarily passed it. They never discussed it. It took no time at all. So I don't know that they much thought was put into it. So I think that this notion that, we should look at the statutory language, which is incredibly unclear, and then think about what it meant in 1964, doesn't seem to lead anywhere for me. So I think there was this movement towards, well, maybe Congress should get to decide now that there is a lot more, now that the arbitration world is so different than it was in 1960s, and also this idea that there should just be deference to the arbitrator. That's as much as I could read from the tea leaves.
So before I open up the questions, I want to go ahead.
I was just going to say one quick thing that was really, I thought, quite humorous is that Breyer said when they started talking about going back to Congress, it says, everybody here has got a lot of money. They can go to Congress and they can lobby all they want.
Yeah. Two things. It was interesting to me that the U.S. Chamber came out very much against 1782 in arbitration, whereas U.S. corporates have availed themselves of 1782 to astonishing success over the years with respect to litigation and arbitration. But they seemingly got to a point where they realized that we're going to get hit with more and more subpoenas, so we're going to be very much against this. But that being said, it does seem like this isn't the last time 1782 is moving before the court, no matter what happens. I mean, I'm sitting here with my creative litigator's hat on. Even if they hold it's not available for arbitration, you still have that reasonably contemplated language in Intel that Justice Ginsburg used. So I can easily see a situation where I'm involved in an arbitration in France. I'm foreseeing a set-aside proceeding coming down the line, and I know that evidence that might be here could be relevant to my case. I have a reasonably contemplated litigation in France on set-aside. I want 1782 evidence so that I can make that argument. I mean, there are going to be issues.
A workaround.
There are workarounds, right, for creative lawyers that got us into the situation in the first place. on the extraterritoriality issue. That's another one that is just, bubbling around and it's all over the place. So it is an incredibly broad and vague statute, and that's given rise to a lot of the opportunities, but a lot of the problems as well.
They also, I mean, you hinted at this with one of your questions earlier, even if the court excludes investor state arbitration from the ambit of 1782 and excludes commercial arbitration, unless and until Congress weighs in, what are they going to do with standing bodies like the WTO or future state to state tribunals that get created, standing authorities, because people don't like investor state arbitration as much anymore. So they're talking about these investment arbitration courts. Even if the court punts on this one, there are other kinds of bodies out there that still present very difficult questions under 1782 that might come back around.
It seems like if the government's in it, we got to be in it. We got to be giving aid to all the international tribunals that are coming about.
And I do want to point out the notion that there's going to be a workaround. You already see that in the cases. Yeah, I've seen a case where they said we contemplate a proceeding in the Cayman Islands. There's actually a lot of these are in the Cayman Islands and the British Virgin Islands. And then they actually filed a lawsuit in the U.S. where they couldn't have, asked for pre-filing discovery. So
I've done that.
You have.
Yeah. You send a letter contemplating proceedings abroad. You get 1782 evidence. You see what you got, and you say, "Oh, this is really interesting. I'm not going to sue the United States." Yeah.
I mean, I contemplate lots of things.
I contemplate everything.
We all contemplate a lot of things.
Especially at my hourly rate, I can contemplate an awful lot.
And I think to the Chamber of Commerce point, it seemed like one of their main concerns was sort of unequal access to discovery. So it's going to be mostly targeting U.S. parties who have evidence in this country that can be subpoenaed, and I think that's a real problem.
Yeah.
And there is a part in Intel that says, well, we can fix that problem if the judge orders reciprocal discovery. They say you can have it, but only if it's two-way. That ends up being not a productive solution at all, because if your request is targeting a third party, which it is almost all of the time, what does reciprocal discovery even mean there? And a lot of the times the reciprocal discovery would have to go abroad, which is going to be, meddling even more than ordering discovery in the US.
Questions from the audience here? Yeah, Kate.
Yeah, I have a question with for 1782 and how receptive the international as far as international tribunals being receptive to 1782 motions, when you're doing it before in the individuality of these tribunals, and if they haven't spoken on it yet, how do you see courts typically ruling? I know we did like a mock one, and it was with Judge Fisher, and that was like a big concern of his, is that who am I to say as a judge now if you haven't even got the tribunal together yet, if they haven't ruled on it? So them not speaking on it, if it's not even formed yet, how do they work with that? I just want to know.
You've probably seen this.
Yeah. I've seen that quite a lot. I mean, they can't, right? They can't determine what the arbitral tribunal wants if the arbitral tribunal has not been constituted yet. And that's where courts have this sort of shortcut, which is to say, well, if we don't have authoritative proof that the tribunal wouldn't be interested in this discovery, we'll simply say it is. And they often also look at precedents. They'll look at a precedent that says, this tribunal is receptive for X and Y reason. But of course, that case also used similar logic. So we kind of have this snowballing effect. As long as some court somewhere said that tribunal is receptive, it becomes receptive pretty much onwards with time. That's the reason why I think it's really important to actually seek out the position of whether it's the court or the tribunal to ask them. It can be the mechanism for doing so can be designed in different ways. But without the foreign court or the foreign tribunal weighing in, there's simply no way to tell. And I think this notion that the US is meddling, that the problem with the US getting involved in these international tribunals is that they're meddling, is a bit of a myopic position, because the whole statute is about meddling. The whole statute is sending discovery abroad, and in many cases, the foreign court doesn't want it. In many cases, it's not in accordance with foreign discovery rules. So this meddling problem seems to be, at least as far as the statute goes, it's not the problem. It's actually the entire point of the statute.
And I think you raised a strategic point there, Caden. It's a good one. Is as a litigant, as a counsel, do you go to your tribunal and ask? Because if you know you need this discovery and you go and ask, and they say we don't want it, and that locks you out of that, man, you're pretty close to committing malpractice there. Wouldn't you rather just roll the dice, go to see if you can find a U.S. judge who's going to order it without having to go to the tribunal? It's a tough question, unless the Supreme Court says somehow you got to ask first, and we got to have the tribunal tell us.
Yes, I mean, it could be that the opposing party
Brings
goes
it
to
up.
the tribunal, and that they try to convince the tribunal to write a letter that says we don't want it. And I've seen that too, in which case usually courts will not grant it.
Yep.
Another possible issue would come up, though, is if the tribunal has not yet been constituted. If I were a judge, I would be very reluctant, absent extraordinary circumstances, from actually deciding the matter. I'd say, wait, deny it without prejudice, or just hold it in abeyance. You go to the arbitrators and ask them. The IBA rules, by the way, with regard to third-party evidence, require that the tribunal give its imprimatur to seeking evidence from third parties by compulsory process.
Professor Brand, you had a question.
When I listen to your argument in the case I call, it's really almost strange because sometimes it seems almost childish, because the word tribunal means arbitrator, that's what tribunal means. And foreign tribunal means it must be a government, because that's what foreign means. Citing 12 different dictionaries. It just seemed really strange to me, and not going to either much of the history or the purpose of the statute. So, Andrea, you mentioned, of course, Hans Smith's article, and I'm sure that if we could bring Hans Smith back and talk to him, but Hans Smith was not just a professor, but he did a lot of arbitrating. And he was he was a Dutch national who benefited when you had to have somebody who wasn't the U.S. national of the tribunal. And so he got a lot of arbitrations that way, and he made more money off it. And if he used the word tribunal, and as you said, Congress didn't spend much time, not much legislative history on this. The statute came, and the draft came, and they pretty much ran it through, right? And so one of my questions is, why not give more credence to what the guy who says he drafted it says it means? Number one. And number two, if it really means courts and governmental bodies, what's the word used for arbitral body in the Federal Arbitration Act, right? Is that not tribunal? Why wouldn't, if it really meant a governmental body, why would Congress not use court or similar body instead of tribunal, which clearly had a much broader meaning?
Court or judicial body, why wasn't that used, for instance? I do think tribunal clearly means arbitral. Yeah.
So as to your first question about why Hans Smith's opinion shouldn't, how much credence should we give it? And by the way, I really do wish I had met Hans Smith, because a friend of mine was his student, and apparently he would throw out large candy bars to his students during class. He seemed like a big personality. Yeah, I'm not convinced that we should give his own perspective that much credence. He was this person who took part in this commission, but I don't actually know who, maybe this is just my ignorance about how statutes are written. I imagine, congressional interns play a role in writing statutes, and should we go to them and ask, what were you what were you thinking that summer when you were interning for so-and-so congressman? It especially, and I mean, my thoughts on this are definitely colored by the fact that the Carnegie Foundation was paying for their commission. But it seems, and this is a bit of a gut instinct here, but it seems not right to think that his opinion should be, that we should be deferring to his opinion.
Well, that's what Judge Bush basically agreed with you, is that he wasn't giving weight to that at all. I'll say, though, is that Hans's son, Rob, was one of the amici.
For the closest thing.
It's a family business.
But in any event, it's just.
I mean, isn't the important thing, though? This I think brings it all back, is, and this goes a little bit to the earlier panel too, is. Was 1925 the FAA was enacted? 1964 for this. The world of arbitration, and especially international arbitration, has changed dramatically, and that's even an understatement. So, shouldn't we be looking, and maybe going back to Congress, as Justice Breyer and Justice Gorsuch said, is the right thing to do, to have statutes here that encompass U.S. policy of encouraging broad third-party discovery and fact development. These are all for the good, but doing so that sort of addresses what arbitration is like these days, and that it is incredibly popular and well counseled in these cases, and we do have to have some sort of restraint on it in order to let it go.
And don't forget, it's frightfully expensive.
It's frightfully expensive. Absolutely.
And one of the key issues that our law students are going to have to deal with in the future is how do they make it less expensive, and particularly for smaller cross-border disputes, which basically are abandoned because there is no feasible way to deal with them.
Right. And it's very difficult for 1782 and for the domestic arbitration and an FAA as well, when you have one party who's very well funded and can go on just a tirade of subpoenas in 1782 and judicial proceedings, and one party who's not. And then you have a situation where it's very unequal. And these are the issues I think we're facing now that weren't there in 1964 and 1925, respectively. Any other questions before we finish up today? Yeah.
So Ms. Edsall briefly mentioned in her initial remarks that there were possible conflicts between Section 7 and Section 1782, which made me think back to the initial panel this morning or this afternoon, and got me thinking, if we were to assume for a moment a world where 1782 does in fact apply to commercial arbitrations, how would Section 7 interact with 1782 for an international arbitration seated in the United States? Mm-hmm. Would it completely supplant Section 7 functionally, or is there some functional difference we should be aware of? Next question.
Yeah, and that's a very good question. It has not. The applicability of 1782 to international arbitration seated in the United States has not been definitively answered by any circuit court. If there is a district court case out there, let me know. I seem to recall looking about a year ago and I didn't find anything. People talk about it. It's a very good question to ask. I do not think it has been definitively answered yet. I think there's a strong argument that if an arbitration is international because it involves a foreign party or performance abroad contract that was international but is seated in Miami, parties to that arbitration may be able to invoke 1782 if the Supreme Court says it applies to international commercial arbitrations. And in many instances, it would be more favorable to those parties to invoke 1782. It might be case by case, the nuances of each case in terms of what the parties choose, Section 7 or Section 1782. But if 1782 is available in those instances, I think you'd see a lot of people starting to invoke it. But it's that example specifically that really highlights the potential conflict with Section 7 of the FAA.
And I don't think that interpretation, meaning that, just because it's seating in the US doesn't mean it's outside of the scope of 1782. I don't think that's inconsistent with any of the other uses of 1782, including the foreign discoverability rule from Intel, which said, it doesn't matter if the sought after discovery is not permissible under the rules of the tribunal. 1782 works according to the FRCP procedures. So if it doesn't matter that, it's not permissible under France's discovery procedures, by analogy, it doesn't seem to me that it would necessarily matter that the arbitral tribunal has different rules either.
One question I just raised in the chat, which I think we can address quickly. When we say the court's thinking about telling the parties go back to Congress, what does that mean? Well, it means that they would hold that that doesn't apply to international arbitration, and Congress can change it if they want to.
Yeah, I think the court would still answer the question presented. They're not going to decline to rule on the case and punt it to Congress.
Right. We're using that shorthand.
Yeah.
I think it's important to note that. Yeah. All right, I think we've reached the end of our time. Thank you, everyone. Thank you to the panelists for coming in, everyone from such a long distance to be with us in Pittsburgh. And thanks for everyone and coming in and listening today, and all the people who joined us online. I hope you found it useful and interesting. So thanks a lot. Yep. Albie had to leave.